Well, hello, everyone, and welcome to One Civil Law. I hope, as always, you're having a great day. We are now going to go live with the transcript from yesterday's hearing in the Karen Reed case from federal court, as I find my mute button. Yes, we are going to cover the hearing yesterday that happened in federal court with the transcript there, too. Exciting. And we're going to go over it and see what the federal judge was asking about and what they're concerned about and what they're thinking and try to get a little bit inside their head about all those things. And as soon as I can find it, because, yeah, there's the transcript. Great. Now I just need to make it look pretty. Fantastic. Let's see. There we go. Great. Margins. Gotta readjust the margins to make it look pretty. Doing the margin song with you and me together. Margin song for you and me. Margins are the way to be. Margin song. All right. Great. We turn our attention to the U.S. District Court, District of Massachusetts, in the case of Karen Reed versus Norfolk County Superior Court and Massachusetts Attorney General. Now, just by way of brief preview, I'm sure many of you already know this, but just to set the scene, we are in a federal habeas proceeding. We would like to not be prosecuted very much. We would like to not be held in jail very much, as the case may be. And we think that there's a basis in federal law for us to not be held. Federal habeas corpus means literally produce the body. Bring me, literally me, I'm the thing. Bring me to court and justify why you're holding me, why you're prosecuting me, and so forth and so on. Her hook, of course, is the Fifth Amendment double jeopardy provision. That's what she has argued. She has argued that the jury, in fact, came to a decision that precludes retrial using double jeopardy. And there are multiple issues relating to this that we've sort of discussed. So we're going to see whether or not what the federal judge thinks, and also, of course, see how much they track my thinking and reassess the odds based on that, whether or not there is a federal double jeopardy issue that precludes retrial. Let's go ahead and go. All right, so we're in the motion hearing in the John Joseph Moakley Courthouse on One Courthouse Way in Boston, Massachusetts. Very exciting. Then we have all the appearances. All right, here's what happened. All rise. Court is now in session in the matter of Karen Reed versus Norfolk County Superior Court et al. Would counsel please identify themselves for the record, starting with petitioner? Good morning, Your Honor. Martin Weinberg on behalf of petitioner Karen Reed, who sits 2 seats to my left, along with co-counsel Michael Pabian, Daniel Yannetti, and Alan Jackson. Good morning, all. Good morning, Your Honor. Caleb Scheilinger for respondent Norfolk County Superior Court. Good morning, Your Honor. Thomas Boken for the Massachusetts Attorney General and also for the Norfolk Superior Court. The court, good morning. All right. This is a hearing on a petition for habeas corpus. I read the filings. I want to make sure we're in agreement on the basic framework, which I think we all are. This is a petition under Section 2241. The petitioner has been released on her own recognizance by the state court, which is a form of custody. So habeas does not attach unless you're in custody, because it's produced the body. Why am I in custody? So the question is she in custody? The answer to that question is yes. She's in custody enough for the purposes of habeas, which incidentally doesn't necessarily mean she's in custody enough for other purposes under some other section of law, but we're not dealing with those right now. We're dealing with in habeas, so she's in custody enough for at least those purposes. Great, moving on. She is not in custody pursuant to a judgment of the state court, in which case we'd be under a different section of the law, in which case there'd be a real problem with Karen Reed. In other words, how about just no, basically? So if there was a judgment of the court that was causing her to be, in custody, that would be a real problem for her. But fortunately, she's not for her. So she has, instead of her odds being basically zero, she has some odds, which are nice. So the section 2254 does not apply. We're under 2241. And that distinction matters because of something called the Anti-Terrorism and Effective Death Penalty Act, which is one hell of a mouthful, AEDPA. The United States Congress basically passed a law that basically says, in so many words, if you've already been convicted and you're serving your time in a prison somewhere, you can only get habeas relief from the federal court if you can show it's a violation of clearly established law that is clearly established by the US Supreme Court. So you need a US Supreme Court decision that already exists that says you were wronged. And obviously, trying to find a US Supreme Court case that's directly on point for whatever your problem is, probably not so much. Those are kind of hard to come by, right? There are a lot of court cases, not many of them are US Supreme Court cases. So if we were under 2254, if we were already serving our time in prison, get wrecked basically. But we don't have that problem, fortunately. We haven't been convicted. We're not currently serving time. We're just awaiting trial. So the AEDPA does not apply. So we don't have to find clearly established law that has been created by the US Supreme Court. We can do something else. Excellent. Our odds improve. The petitioner here has exhausted her state court remedies, and none of the extension, that's abstention doctrines, that's abstention, court transcriber. You made a mistake. They didn't say extension, they said abstention. Bad court reporter. The petitioner has exhausted her state court remedies, and none of the abstention doctrines, such as Younger and Harris, apply, which is, a bit of an open question, to be honest. I don't think they do apply, but it's a non-trivial question. We talked about this on Melanie streams before, right? Whether or not the court would even hear the case at all, right? Abstention doctrine. So they say it doesn't apply. I think they're probably right, but it's a non-trivial concern. So it presents basically the federal constitutional question of whether her retrial would violate the Fifth Amendment right to avoid double jeopardy as incorporated in the 14th Amendment that applies to the states. Fair enough. That is a legal question that I'm to consider de novo, all the way by saying I'm trying to make sure we're all in agreement on those points. Basically correct. Mr. Weinberg, are you taking the lead here? Yes, I am, Your Honor. Do you disagree with the way I framed the question? I agree entirely with the way you framed the question, Your Honor. Never hurts to kiss up to the boss, people. Never hurts to kiss up to the boss. Respondent also agrees, Your Honor. So we all agree that 2254 does not apply, which, by the way, the 10th Circuit would disagree with that. We read that decision, or we at least read the reference to the decision. So in the 10th Circuit, if we were in Colorado, the Colorado court would say, 2254 applies, despite the fact we're under 2241. But we're in the First Circuit, so we don't have 10th Circuit problems. So that's nice. And the First Circuit has already said they disagree with the 10th Circuit. So we already have a First Circuit case telling us that. So that was nice. Great. All right, the court with that. Mr. Weinberg, I'll hear from you. Thank you. May I address from the podium? Yes. Mr. Weinberg, thank you. This petition presents to Your Honor two legal challenges to state court decisions, both by the trial court and later by the Supreme Judicial Court. The first legal challenge is whether or not there was manifest necessity for the trial court's sua sponte declaration of mistrial, and we contend, and I'll argue in a second with Your Honor's permission, that the decision conflicts with clear-cut First Circuit jurisprudence, which requires a consideration of viable alternatives and requires a trial court to consult and give the opportunity to all counsel to be heard before any mistrial order occurs, and requires some evidence the constitutional right of a defendant before the trial court to have the first jury decide, this is a long sentence, to have the first jury decide whether or not there was sufficient evidence to convict or acquit needs to be demonstrated on the record, deep breath, and the record of that case demonstrates no consideration of Miss Reed's double jeopardy interest. Anytime they want to find a period will be fine. But I want to start with the second argument of why there is little precedent. But I believe strongly the court should establish precedent that the right to a post-trial voir dire is an essential part of the Double Jeopardy Clause protections that center on the right of the defendant, or in this case, the petitioner, not to be subjected to the same sovereign to be prosecuted for the same offense for which a jury has ultimately determined that a state court failed to prove their case. In this case, that right dates back. I'm not going to burn the history with the court, but okay, I'm just going to have to insert a period here myself because I need to take a break so we can discuss some of these concepts. I was going to wait for the end of the sentence before interrupting what they're going to say. I'm sorry to interrupt it all, but I'll let you finish. But we got to discuss some other stuff first. Man, what a sentence this can be. All right. First of all, so let's discuss this in a little bit more detail. All right. So the issue of manifest necessity, of course, is ultimately an issue of federal law, to be sure. Whether it's clear-cut jurisprudence is debatable. Does the First Circuit jurisprudence require consideration of viable alternatives? Yes, it does, but that's not necessarily sure exactly what form that takes, to be honest. And does it require a trial court to consult and give an opportunity to all counsel be heard? In my humble opinion, it does not require that. The First Circuit case itself said there is no mechanical test. It said it right in the First Circuit decision. There is no mechanical test. So if the judge was required to consult with the attorneys, that would be a mechanical test because it would mean if this thing, therefore this thing. That would be mechanical. But there is no mechanical test, so it can't mean that. What the First Circuit wrote instead is it is a factor. It is a factor to be considered along with other factors, some of which we're not necessarily even telling you what those factors are, because there's no mechanical rule. But it's a factor that you might have to do. So the failure to consult with the attorneys is an indicia that the court did not necessarily do manifest necessity, but not necessarily dispositive. Fun. Okay. And then they go on to say that they think the court should establish precedent. The right to a post-trial voir dire is an essential part of double jeopardy protections. Yeah, I can't find any case law that says that either. And they're not saying there's any case law, right? They're not saying there's any case by any federal court, presumably anywhere, none has been cited or brought to my attention, that would require this kind of voir dire. So this would be the first federal court, presumably ever, to say it. And I don't think they're going to be likely to say it on a habeas posture. Technically, they could say it on a habeas posture, but I think the habeas posture might still constrain them from as opposed to a direct review of a federal court. So if we were on a federal appeal from a federal district court, I think they'd be more likely to say what the federal law requires rather than it being a habeas petition, which, by the way, for the record, is not an appeal. I know people say that all the time. They say it colloquially even. Sometimes attorneys will say it, but technically this isn't an appeal. We haven't appealed to the federal court. It's a collateral attack. And so those kinds of distinctions actually matter because collateral attacks, generally speaking, are disfavored. Not just habeas, any sort of collateral attack. So you can appeal, and that's one thing. You're going vertically when you're appealing. When you're doing a collateral, you're attacking it from the side. And that is disfavored in law, generally speaking. So I think it's unlikely they're going to establish brand new precedent if it's the first time someone has to do it. They technically could, but I don't think they're going to. But, fair point. All right. And also, by the way, there is also this lurking issue that is not presented here when they say the prior jury unanimously determined the state failed to prove their case. There's also the issue of, as a matter of the federal law, because of course we're in federal court, as a matter of the federal law, are partial verdicts required? So I know what the Massachusetts state rule says. We're going to ignore it for the moment because we're in federal law and we need federal court with a federal law, right? So what Massachusetts state rules say is interesting and all, but it's only binding on the state, right? So the question would be, as a matter of federal law, does a court have to accept partial verdicts? So assume, putting aside what the rule in Massachusetts says, put aside the rule. As a matter of federal law, if the judge had brought in the jury, and if they said, hey, do you have a verdict? And the jury said, well, we're innocent as to 1 and 3, but we're not sure about 2. Could the judge, as a matter of federal law, say, well, I'm not going to accept any of those verdicts, mistrial across the board? Can they do it? And I don't know of any law that says they can't. I don't know of any decision that says they can't do it. Can a judge insist on complete verdicts? I don't know of any law that says they can't. So like there's that lurking issue, right? So it's like, even if they had done that, is that sufficient? Is that sufficient to trigger double jeopardy? Even assuming that the jury's decision is final with respect to counts 1 and 3, which is one heck of an assumption. But even assuming it's final with respect to counts 1 and 3, does that matter if they can't reach a verdict with respect to 2, with respect to federal law? That's a very interesting question in my mind. Cool. All right, picking up with the very long sentence. But Arizona versus Washington has a footnote talking about how the history of double jeopardy centers on people's right to avoid multiple prosecutions, that it's more at the core of double jeopardy than even the right to avoid multiple punishments, that dates back to the era of the British history where a Stuart case would have had a practice of starting trials, and if the evidence wasn't good enough, they would abort the trial and reserve it for future times, and the British responded to that, and the colonists later, the framework of the Fifth Amendment Double Jeopardy Clause, built the foundation that history and is repeated in the Supreme Court several times. Yeah, I mean, fair enough, but very broad level. Very broad level. Prosecuting people for the same offense twice is bad. We shouldn't do it. Yeah, we're all sort of on board with these broad propositions. But of course, once we get into the specifics, that's where things get a little bit more interesting and more detailed. Cool. What's indisputable here is the petitioner has carried her burden of production. Well, no, not really, because it presupposes that it matters legally, right? The burden of production is the amount of evidence necessary to make a legal argument, right? Basically is the easiest way to think about it. It is the bare minimum amount of evidence necessary to make a legal argument, any legal argument, right? So for example, self-defense is a good example, right? The state has to disprove self-defense by beyond a reasonable doubt, but it is considered an affirmative defense, which means that although the state has the burden of proof, the defense does have the burden of production. And this is a pretty fine distinction, by the way, and so you probably don't hear about that a lot, but it is technically correct, which of course is the best kind of correct, right? The defense does have the burden of production. So what does that require? If you want the defendant to even be able to argue self-defense, they have to put forward some evidence, any evidence at all, that it is self-defense. But if they can't even do that, if they can't produce a scintilla, as they might say, then they can't even argue the defense, right? And the state doesn't have to prove anything. So does Karen Read have the scintilla? Well, only if it matters legally, of course, right? She's like, well, you know, we can assume that all 12 jurors would say that. It's like, okay, but what is the legal impact of that, right? And that's what we're sort of talking about, right? What does that mean? Which is, of course, a question of law. So I don't know whether or not she's met her burden of production because I'm not sure whether or not it legally matters for the reasons we've discussed. It's virtually unprecedented. We haven't found any federal precedent where 4 jurors have directly responded to defense counsel and the state court accepted defense counsel's representations as being reliable in terms of making a factual predicate for the decision-making. I mean, I don't want to belabor the point unnecessarily, but even if we had affidavits from all 12 jurors at this point, we'd still be asking the question, what does that mean? Right? That's sort of the problem. That's what does that mean? So we have to figure that out first. 4 jurors have directly informed trial counsel, my co-counsel in this case, that there was a mistake made, that they have unanimously come to a decision to find Ms. Read not guilty on 2 of the 3 counts against her, and the impasse was documented in the final, actually in several notes, but the final note that Judge Cannon relied on related not to all 3 lesser counts, but instead to multiple charges that includes lesser included offense with manslaughter count 2. And thank you finally for finding the period. There were 2 reasons advanced by the Commonwealth as to why voir dire should not be ordered. And the word should is a bit problematic, right? There's a big difference between should and must, right? So that's a big problem. And voir dire could establish whether voir dire was conducted by Your Honor. I think Your Honor has the power as part of this habeas corpus proceedings to order voir dire. Maybe. The court says, let me pause you there. Is that correct? In other words, if I find there was no manifest necessity for the declaration of a mistrial, or I find she was acquitted, I ordered her release from custody, whatever that means in this context? Yes. Well, possibly, yeah, that's what that would mean, right? If double jeopardy applies, then 1 and 3 presumably go away, and potentially 2 as well, because the failure to consider the mistrial would be now something that would pollute the entire proceeding. So yeah, that would be potentially the ramification of that. If the judge failed to consider things that trigger manifest necessity, then it also doesn't matter what the jury thinks. We can also actually, ironically enough, in that situation, we can also disregard the jury because it also no longer legally matters. It just no longer legally matters the other way, which is fun, right? This is why we have fun over here in law land, right? So we can disregard the jury and what they said because it no longer matters, because the mere failure of the judge to do the manifest necessity thing means there was no manifest necessity, means double jeopardy applies, means the whole case goes bye-bye. Not because of what the jury thought, but because of the judge's failure. So it also doesn't matter what the jury thought, but for opposite reasons. That's fun. All right. Let's carry on. But the standard habeas relief, but voir dire, do I have the power to do that? And if so, from what source does it derive? Because that's not habeas relief. They're not releasing her from custody. That's conducting an investigation. Fair. Yes, it would be the power to conduct an evidentiary hearing, would be the power to make fact findings as to whether or not the jury unanimously misread, presumably acquitted. It would be part of the jury's power, or part of the court's power, ancillary to the constitutional decision of whether it's an acquittal, what constitutes an acquittal, and how do I know whether there's an acquittal? Okay. And I'm not asking the court to simply take the 4 declarations of the fifth, who directly communicated with Mr. Iannetti, but use this as a basis to find petitioner satisfied the burden of production. Right. So if what the jury thinks matters, we would have to call all 12 members of the jury into the court. Which court? I'm not sure. But we definitely have to call them into some court because, well, 4 or 5 of them say it's true, but who knows what the others would say, right? So if we're going to do this, the only way to do this is by bringing in all 12 members of the jury and asking them if it matters, because we need to make sure that all 12 members agree as to what these other members say. That's typically what you do when you poll a jury, and why would this be any different, right? Great. I mean, we have many examples, where the burden of production results in voir dires, both federal and state, occur from a single juror's declaration. There was ethnic bias against Hispanics, a racial bias. So when there's an allegation of an external contact, an allegation that extrinsic information somehow perpetrated the decision-making. Yes, fair enough. So a statement by one juror may be sufficient to conduct an inquiry. Fair enough. Right? If it legally matters. So one juror saying the jury was racist, they did the racist thing. Let me tell you about the racism. That matters. And so whether or not we need to call in just that one juror or other jurors, I don't know necessarily, but yeah, that would be enough to make that inquiry. So one juror, and even if they had one juror, incidentally, like even if Karen Reed, if all she had was one juror, I mean, that might be enough, assuming it matters. So if one juror came forward and said, no, we're all unanimous, and we didn't hear from the other 11, I'm not sure that necessarily changes the equation at all. Because again, if we had all 12 saying it, I'm not sure it changes the equation. So 1 might be enough, 12 might not be enough, because whether or not it has legal impact. I'll take a pause here to answer a couple questions and give you guys a chance to catch up since I've been ranting for a little while. So let's ask some questions and we'll go for it. No juror came forward to dispute it. Yeah, KPT, I really dislike that argument very much. I really dislike the no juror has come forward to dispute it argument, because every member of the jury has been told and is correct they're under no obligation to talk to anyone unless there's a court order. And assuming, for the sake of argument, assuming there was a juror who would say, no, that's not true, we weren't unanimous, I can think of some reasons they might not necessarily be super thrilled to make themselves known necessarily. So I really dislike the no one else has come forward argument. The silence is not really working for me. That doesn't really go anywhere for me, but that's just me. If there's no manifest necessity and mistrial was ruled, what's the rule of the habeas dismissal? Yep. Yeah, so if failure to do manifest necessity and also consent, which we'll see whether or not the court's gets into later, but assuming there's no manifest necessity and assuming Karen Reed didn't consent, then what the jury thinks is irrelevant, end of analysis, case over, double jeopardy applies, everyone goes home. Yeah, that's it. Has there ever been an occasion where jurors have been called back in for questioning after trials ended? Sure, it's happened. And incidentally, we saw it ourselves. We saw it in the, what was it? Was it Take Care of Maya with juror number 1? Yeah, we actually saw it. We actually saw it happen once on stream. We watched juror number 1 be brought into the courtroom and ask questions. And then I had an interview with juror number 1. It was fantastic. We stand for juror number 1. He's awesome. Yeah, so we definitely see it happen, but it's not something that happens often. It's very, very rare. Did we see it after Murdaugh? Yes, we did. As a matter of fact, we did see it after Murdaugh as well. You're correct. We also saw it with respect to Murdaugh, where jurors were asked whether or not the clerk of court interfered with them. So yes, another situation which you've seen it. You guys have seen it twice. That's a lot for you guys. It doesn't happen every day. Yeah. All right. Yeah. Becky, the clerk court, the clerk of court. She was a riot. She's fun. Her book was awesome. I bought her book, which she plagiarized and then had to withdraw from the market. Very sad. Oh, Lord have mercy. All right. Pressing on. Let's see. Okay. Here we have 4 distinct, 1 indirect declarations. I think it's indisputable Miss Reed has met a burden of production, and the real issue should she have the opportunity to convert that burden of production into proof the jury unanimously and finally and unconditionally acquitted her of charges, including the most serious charge she's facing on re-prosecution, that being murder. And the Commonwealth, I think their positions, when you penetrate the arguments, come down to 2 points, and I want to address each of them. Point 1 is they argue that even if 12 jurors came in, whether this court or Judge Cannon's court, and Your Honor would have the option, I contended, to order the voir dire, with Judge Cannon as part of the fact-finding to determine if there's acquittal. If 12 jurors each reliably, credibly answer the questions that are not inconsistent with questions a trial judge like yourself might poll a jury, did you find a decision on count 2? Was it unanimous? Was it final? Was that your decision? If 12 jurors credibly said, we made that decision, it was final, it was not reconsidered, it was to vote not guilty, the state's position is we should somehow create a procedural wall that prevents those facts from being heard and those facts to crystallize the decision. Yeah, that's exactly what the state thinks. And not unreasonably, unfortunately, as a matter of the legal principles. This is I don't always get to tell you what you want to hear. I just try to provide you the best legal analysis. And sometimes I have to tell you bad news. I'm sorry. I don't want to be the bad guy. I just want to try to give you the best legal understanding one man can bring you. So the Commonwealth sort of has a point here, and not unreasonably so, with respect to this particular issue. On this issue, it's like, okay, yeah, even if all 12 members said that, is that enough as a matter of law? And if so, why? As a matter of federal law in particular, because of course we're looking to the federal court for federal relief. So what federal law do you have on that proposition? And, it leaves something to be desired. The federal law is not great. Now, the First Circuit, fortunately, because they're not under 2254, they're under 2241, isn't quite as hampered as they otherwise would be. So their ability to come up with new and exciting answers is possible, although the habeas posture somewhat discourages them from doing so, but doesn't strictly prevent it. But yeah, that's another thing for another time. Mr. Weinberg, we of course contend that the kind of finding by a jury, which we believe was made by the jury but not disclosed by the jury in the notes, is an acquittal. That the acquittal is not an announcement, it's not formality of a verdict, it's a decision by the jury that's unanimous. It's at the heart of the right of the jury trial. I mean, the Sixth Amendment right to an unbiased jury. Yeah, you're not necessarily doing great, incidentally, when you're doing this really high level stuff, right? This is not super encouraging from a legal posture. It's like, let me tell you why America is great. We have a Fifth Amendment. It says double jeopardy. We have the Sixth Amendment. It says there's a right to trial by jury, right? That's not super duper encouraging. Unfortunately, what it means is I don't have anything more specific, because if I had anything more specific, I'd be telling you about that, but I don't. All I've got is like some 30,000 foot overview stuff, and not the best posture to be in that you could possibly want. Yeah. All right, pressing on. All right, I mean, the Sixth Amendment right to an unbiased jury is really in part predicated on defendant's right to an acquittal from an unbiased jury. And here we have powerful evidence, compelling evidence. A jury reached a final decision to acquit Ms. Reed, and the state's position is, so what? We have a right to re-prosecute, who cares? Yeah, the kind of sort of, that's their position, yeah. They didn't come out. A mistake was made. The jury didn't announce the verdict. They didn't write a footnote to their impasse note. A mistake might have been made by the trial court, which I'll contest when we discuss manifest necessity, not to ask the jury whether or not the note reflected an impasse on all rather than just a subset of charges, but a request for voir dire to make sure there is hard proof, reliable proof. If it's not there, then there wasn't a unanimous acquittal. But if it is there, there's unanimous finding by the jury, it's entitled to respect. Again, presuming implicitly that as a matter of the federal law, the court was required to accept partial verdicts. The ghost says, you disagree, it means the process is so effed up it butts directly into an amendment. No, you as a lawyer, you want the most specific thing you can, because you're trying to look for an analog, right? Because we work on a precedential system. We work on precedents. It's the nature of our common law system. So you want an analog to your case that says, I win. The closer the analog, the better, right? The closer the analog, the better. So if you can find a case that's really on point, that's really good, right? And the less on point it gets, that's not as good because it's vague. So, right, I mean, I understand that they're trying to find a constitutional hook in the Fifth or Sixth Amendment. I get that. But what they don't have is the anything specific, right? They've gone all the way from, the ideal, right? The ideal is I have a case that's directly one for one, it's on point, every attorney's dream, right? That's the dream. And they have gone all the way from that dream to the outermost orbit of there's a Fifth and Sixth Amendment. And not great. It's not a great position to be in. The court. So let me ask you this. Let's assume you're correct. How do you reconcile that with the Supreme Court's decision in Blueford versus Arkansas, which is a 2012 decision? The foreperson of that jury comes back and we say, we have unanimously voted to acquit not just on murder, capital murder, and to acquit on first-degree murder, but we're deadlocked on manslaughter. And the Supreme Court said for double jeopardy purposes, that's not an acquittal. How do you reconcile that argument with that case? That's a pretty good question. That's a pretty good question, and I already know what their answer is, but we'll get to that in a second, right? So in Blueford, in that case, the jury came back and said, They basically said, we're not guilty as to count 1, but we can't make up our mind as to count 2. They basically said exactly those words. And the judge said, not good enough. Not good enough. I'm sending you back. Right? Now, doesn't that sort of imply the judge is not required to accept partial verdicts? Because it does to me. It does to me, right? If the judge was required to accept partial verdicts, then Blueford would have been decided differently, right? What the Supreme Court would have said is, no. The jury said not guilty as to count 1, and that's done. That's done now. Now, if you want to order them back as to count 2 with further deliberation because you want them to try again on count 2, you could presumably do that. That might be fine. But you had no choice but to accept that not guilty because that's done now, right? But the Supreme Court didn't say that. They didn't say anything like that. They said that the trial judge made no mistake in sending the jury back to reconsider the entire case, at which point, of course, the jury now no longer knows what it thinks about anything. Way to go, jury, right? They no longer know what they think about anything. Now they're hung across the board. And the Supreme Court said that was fine, right? So if they were required to accept partial verdicts, the Supreme Court wouldn't have said that. They would have said, no, that not guilty as to count 1 was final. Maybe count 2 is still live. Maybe that's still live, but count 1 isn't still live. But they didn't say anything like that. They said the trial judge didn't make a mistake by sending them back and reconsidering everything, even though it led to a hung verdict. So it seems to very strongly, to my mind, imply partial verdicts are not required. Because if they were, the decision would have been different, right? That's what I think. But that's me. That's the way I interpret the law. All right, so he's going to try to answer this question relating to Blueford. Al Dente says that's ridiculous. Be that as it may, it's the law. I'm a legal educator. That's the law. Pressing on. Yes, the majority opinion was relying on 2 factors that are different than factors before the court. First, there is idiosyncrasies of Arkansas's law that required either an acquittal on everything or conviction, but doesn't allow for the kind of partial verdicts that are part of federal law and part of Massachusetts law. But they don't have to be. They don't have to be part of the law. And you're seeking federal relief. You're seeking federal relief. So can a state require partial verdicts? Sure, why not? But can they insist on complete verdicts? Can they do that? Well, the Supreme Court seemed to think they could in Blueford. I mean, Arkansas required complete verdicts. No partial verdicts in Arkansas, apparently. Okay. And so the Supreme Court didn't have a problem with that. So no partial verdicts. That seems fairly dispositive of the issue to me, to be quite honest. Pressing on. But even more importantly, the trial judge, right or wrong in the Arkansas case, sent the jury back to deliberate. Well, no, if it was wrong, if partial verdicts were required, then we're done, I would think. And the majority was very clear they were predicating their decision. There was not acquittal on the charges the jury person informed the court on. So even though the foreperson says we're all unanimous, that doesn't count. Based on the lack of finality of those decisions, based on the fact the jurors had the right to reconsider, based on the fact there was known to be deliberation that continued after the announcement. So even the jury saying in open court we're unanimously not guilty doesn't necessarily count, says the U.S. Supreme Court. You don't have to like it. It's the law. Okay? Great, moving on. Partial verdicts are acceptable in other states? Yeah, many states allow partial verdicts, including, incidentally, Massachusetts allows for it. It's in the rules. It does allow for it. Yeah. So states can allow for it. They can even go so far as to require it if they want. Nothing stops them. So if they want to require partial verdicts, they can do that too as a matter of their state law. That's fine. Yeah, no problem. In this case, we don't have a record. There's no factual basis. None of the other 7 jurors, despite the media I don't like this argument. Despite the length of their jury service, despite notes saying we have a principal disagreement with other jurors. Yeah, I don't like that argument. That doesn't get anywhere with me. Not that it even has to, incidentally, by the way. It just doesn't, I just don't like the argument. The other 7 jurors haven't said something, so they must agree. Yeah, silence means we agree. Although, to be fair, in the issue of consent, which we'll get to, it kind of does, but that's another issue for another time. Pressing on. After 2 months, I think you can infer or expect the likelihood that at least one of those jurors, anonymously at least, would tweet, would reach a media, would reach the court, would reach state police. Really? I don't know about that. I'm not sure necessarily that a juror would be necessarily thrilled to reach out to the state police at this point, but okay. Would reach a court officer and say, wait a second, that's a misrepresentation of what happened in the jury room. That wasn't a final vote. That wasn't a vote to acquit. That was just preliminary. But there's absolutely nothing in this record, despite large publicity, that featured the filings of original motions to dismiss and the affidavits of counsel and the declarations of jurors that conflict with it. I don't like that argument at all, but that's okay. There is a likelihood here, Judge, that if you order voir dire, we would end up with proof that would essentially extinguish all the state's concerns that, like Blueford, this wasn't just a final vote. This was just a preliminary vote. We can infer the jury has a right to reconsider. Yes, the jury has a right to reconsider, but there's no evidence in the record they did reconsider. That there wasn't a final vote, that they ever thought of it as anything other than a final, unconditional, ambiguous acquittal. I'm not necessarily sure I like that argument either, incidentally, by the way, because if you assume that the jury like is just sitting in the back room and like there's no notes coming out to the judge, right? There's nothing that precludes a jury from being like, okay, we're all unanimous, and then they discuss other things for a while, and then the juror says, well, I changed my mind, right? They can change their mind sort of any time until it's, until the fat lady sings, as someone might say. So, even if all 12 of them agree, it isn't necessarily final. It's not final till it's final. And whether this is final, I suppose, is another issue, but, it's not final till it's final. Thank you, by the way, for the 3,151 of you who are spending some time with me. And thank you very much to Attorney Melanie Little for being so kind as to send some people my way. That was very nice of her. We do love our cupcakes. You guys are great. And just a friendly reminder, if you haven't already, you can always hit that subscribe button. We do really appreciate it. Hit the like button. It helps with the algorithm. And did you know, for a mere 99 cents a month, that's right, less than $1 a month, you too can become an uncivilian. It's true. It is literally the least YouTube will let me charge you. I can't charge you any less than that. And for $1, you get to be a member, which includes behind the scenes content, such as cooking streams or editing streams sometimes, or sometimes streams go wrong and then I make them members only because I was kind of embarrassed, but you get to see my embarrassment. You get some cool emojis and you get that warm feeling in your heart of being an uncivilian. All those things are nice. So you should do that. Become an uncivilian today. We do appreciate it. You also get that feeling that you're just a little bit better than everyone else in chat who isn't an uncivilian. You're just a little bit better than them, and you can wear that badge with pride. And again, a mistake was made. Perhaps the trial instructions said you need to reach a verdict on each count. The jury notes reflect, or at least we contend they reflect an impasse on count 2, but not count 1 and 3. I don't know how you're getting that from the jury notes, but fine. The court, I'm sorry to interject. If I hear you correctly, my power to conduct such a voir dire or to order that to be conducted is ancillary to the habeas jurisdiction. Yeah, I mean, fair. Yes, it would be as if the court was, doing a habeas on incompetency of counsel. Your Honor would be empowered to take evidence and decide, did counsel have a conflict? Were they asleep at the trial at the table, which incidentally, by the way, isn't necessarily enough to get ineffective assistance of counsel. We've seen cases like that. Is falling asleep necessarily enough to be ineffective? Nope, not necessarily. Law is fun sometimes, it's great. Or were they drinking during trial? Also not necessarily disqualifying. Well, I mean, if they're going to go after attorneys for drinking in the middle of trial, man, what's next? What's next, man? You know, federal courts on habeas can take evidence, and there's nothing in the habeas rules that would prevent you if you believed you needed the voir dire to make final determination whether it's unanimous and final acquittal to take evidence, and therefore there's nothing to prevent the court from determining that the jurors should be called. They should be seated anonymously. It's better in this courtroom. There's no cameras. In terms of protecting their privacy rights and getting credible evidence. Fair. You know, we know from the First Circuit's decision in Zarnoff, where 9 years later, the First Circuit ordered Judge O'Toole to have a voir dire. Yes, it is possible that voir dires can be much after the fact. That is fine. That can happen. So the time factor is not necessarily the problem. That can be things. Voir dires are not extraordinary. For the jury, it's a little extraordinary. I'm not going to lie. In fact, the First Circuit has said in the Zindi case, which adopted by the Zarnoff case, we can't have a dogmatic rule against voir dire. Not having a dogmatic rule and them not being extraordinary is definitely not the same thing. We have duties when there's credible evidence. The court, but where Zarnoff is a federal court examining its own jury, which, as I mentioned, we're on a habeas posture, which counsels a little bit more restraint than might otherwise be observed. We live in a federalist system. The federal government is sovereign. The states are sovereign. And the federal government doesn't like to interfere with the state governments unless they kind of have to some degree, particularly as it relates to criminal proceedings, because the dominant criminal law is state level by far. You know, federal charges are much, 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 much more uncommon than state level charges. So the federal government really doesn't like to mess with state level stuff unless they necessarily have to. So the posture is important. You love the hat? Thank you. I love my hat too. It makes me happy inside. All right. But what the Zarnoff was a federal court examining its own jury. You're essentially asking the federal court what happened here in state court. It may be no different. Yeah. I'm not expressing an opinion, but it feels different. It feels a little different to me, to be quite honest. Maybe that matters. Maybe it doesn't. Is there precedent for a federal court to require a voir dire of a state court jury? There is no precedent I know of where any court judge, any federal court, has dealt with voir dire for an acquittal issue. Yeah. So, fun. Right? There's no precedent. This is a case of first impression, Your Honor. Exciting. Exciting. Would you like to make up some new law now? Right? Would you like to make up? Someone has to be the first. Would you like to be the first? Would you like to make up some new law? Oh, man. This comes to you on a pretrial basis, which is unique about double jeopardy. There are other cases where state court has voir dires on a regular basis, and the federal court has voir dires on a regular basis when any juror declares there was external contact. I suppose, but that doesn't happen every day. There was a bias in the jury room. There was prejudice against a Hispanic defendant, or really one of any race for racial reasons. And you know, we're arguing in those, there are Sixth Amendment-based voir dires, but the values are represented by the Double Jeopardy Clause are just as important as the value of an impartial jury. Fair enough. And it's only that there's no precedent. Again, not a fun position for a lawyer to be in. Not fun. Like, would you like to be the first ever, Your Honor? How are you feeling today? Feeling good? Yeah. What jurors have said, wait, we acquitted the defendant and judge didn't listen. We provide the court with two court opinions, the Dotson case and the Fifth Circuit, the Stauffer case. In Dotson, two jurors heard the verdict, read in court and said, wait a second, that misrepresents our unanimous decision to acquit on defendant of one count. I think it was an extortion case. The judge called the fourth person executed an affidavit, and the judge reversed that part of the verdict slip. Yeah, but that was a slightly different issue and also it was interesting because the judge switched the verdicts. So that was a 10th Circuit case in which the jury, for some reason, switched their verdicts right? We didn't mean to find them guilty on that extortion count. We meant to find them guilty on the other extortion count. And so all 12 jurors, provided statements to the court, and the court was like, okay. And then they swapped. And the judge said, okay, fine, I'm just swapping the verdicts. And then, of course, the person said double jeopardy. You said you're changing my not guilty into a guilty. It's like, no, I'm just correcting the record. And the 10th Circuit said that was fine. So no problem there either. Yeah. I mean, it was the defendant who asked. So, I mean, there's also that too. Marissa says, Kurt, your insights are on point. Love the sparkle. I love this stuff, man. This is where I live. I love this stuff, man. We're discussing legal issues. This is so much fun. And it's so much more fun because you guys are here. Not going to lie. It's a lot more fun when there's an audience. There's a lot more fun when you guys are spending time with me and enjoying it. And I appreciate that you guys are here and spending some time with me. I love this stuff. It's what I live for. It's great. In Stauffer, it was cause to defense counsel. That's as close as the precedent gives us as to what occurred in this case. And that's why I want to start the argument here, because manifest necessity has been the subject of an enormous amount of opinion and some pretty clear First Circuit guidance and Supreme Court guidance, in which the Supreme Court, by the way, said no particular thing is required. So they said nothing in particular is required. I'm cute. Aw. But we're here in a bit of legal wilderness where Your Honor has less bench posts, less presidential bench posts, and more needs to make a decision about right or wrong. Ooh. Yeah, I don't know about that one. Yeah, you think courts are about right and wrong? Who told you that? Courts aren't about right and wrong. Courts are about legal and not legal. Don't you know the difference? Lol. Whether or not, given the level of proof, there was a unanimous finding of not guilty, whether we should just insulate it and, to me, not honor the services of those jurors who spent 2 months sitting and listening to evidence and contend we came to conclusions the evidence did not prove Miss Reed was a murderer, did not prove she left the scene to avoid, but they were hung on whether or not there was some level of manslaughter. I watched part of that interview with the juror, and it somewhat made me lose some of my faith in the system. John O'Keefe was there. Karen Reed was also there. Therefore, Karen Reed killed John O'Keefe. Personally, maybe it's just me, but I feel like there's some other steps between Karen Reed was there and John O'Keefe was there. I feel like I need a couple more things before I get to Karen Reed did it. But maybe that's just me. I don't know. Not for nothing, by the way. Like the juror said, Karen Reed drove to the scene. John O'Keefe's body was there. Therefore, Karen Reed did it. You know who else drove to the scene? The tow truck driver did. Remember? He drove to the scene. He testified to it. Maybe it was the tow truck driver. He was there. Then the body was found. Maybe the tow truck driver did it. Anyone think about that? The state's argument, I think, says you can't have an acquittal without announcing it. And the state's other argument is under 606B. How do you conduct a voir dire without, intruding on the deliberative process? And let me take both those on. The most recent Supreme Court case that has dealt with this, just what constitutes an acquittal, is McClath versus Georgia. What a great case that was. That was so screwed up. What a great case that was. That's so screwed up. In Georgia, they had a state law that says if there were inconsistent verdicts, that the state court was empowered to invalidate an acquittal. All right, yeah, it's like right away you guys know there's a problem, right? Right away you guys know there's a problem. Yeah, that was Georgia's genius contribution to the fight. All right, so the U.S. Supreme Court has said as a matter of their law, they don't care about inconsistent verdicts. Inconsistent verdicts are fine. So you can find guilty on the felony murder even though you acquit on the underlying felony. The Supreme Court says that's fine. Again, it's just the law. Don't look to me. I'm the messenger. I'm not the bad guy. I'm just telling you, okay? You can have inconsistent verdicts. All right. So that's fine. So then Georgia, and the judge incidentally accepted the verdicts. The trial judge accepted the verdicts. So the trial judge accepted the jury where they said not guilty on one charge and guilty on a different charge. And even though there's really no way to do both those things at the same time, but the trial judge said that was fine, which is a matter of as far as the US Supreme Court goes, that would be cool. Okay? I mean, it doesn't make sense that you can do both not guilty on count one and guilty on count two at the same time in this particular context. Both those things don't really make sense, but let's pretend they do and move on. It's like, okay, so the Georgia Supreme Court was like, that is intolerable to us. That is intolerable. I'm like, okay, that's fine. If you want to disagree with the US Supreme Court, that's fine. If you want to say we can't have inconsistent verdicts, we're not willing to tolerate it, we don't know what the US Supreme Court is going to do, talking about, then what we're going to do is change the guilty to a not guilty, because that would make the verdicts consistent. But what the Supreme Court of Georgia decided to do was choose a different fun option. They didn't say they didn't say let's change the guilty into a not guilty to fix the conflict. They said let's void the acquittal. You know that not guilty verdict that was read by the jury in open court and accepted by the trial judge? You remember that? Let's void it. Let's void the acquittal and let's re-prosecute them all over again. The US Supreme Court did have a problem with that one. They did have a problem with that one. They're like, that doesn't work for us. You can't fix it that way. You can't fix it that way. Oh man, good times. So in Georgia, they had a state law that says if there was inconsistent verdicts, then a state court was empowered to invalidate the acquittal. And then the Supreme Court said it's well established that whether an acquittal has occurred for the purpose of the Double Jeopardy Clause is a question of federal, not state. An acquittal occurs when there's been a ruling relating to the ultimate question of guilt or innocence. Labels, including those provided by state law, do not control our analysis, which generally speaking also is true. We don't do law by magic words. The label is not the thing. The label is not the thing. So you can try calling it something different, and lawyers and sometimes even judges try. It's like, let's call it something different. But a spade is a spade no matter what you call it, and the higher courts are not usually that dumb. So the label is certainly not the thing. I agree with that. Thus, it was not dispositive whether a fact finder recanted the word acquittal. Lol. Let me read some of the super chats that have come in so far, because I think I've missed some of them, and now's a good time. Maggie became an uncivilian. Gretchen Shea became an uncivilian. Mama Bear of One became an uncivilian. I thought you already were an uncivilian, but it's nice to have you back if you rejoined your membership. Snacks gifted 20 gift memberships. Tony P gifted 10 gift memberships. Carolyn McDonald became an uncivilian. Orphan Mythology became an uncivilian. Michelle Mogden became an uncivilian. Paranoia 07 said, bring Melanie in for a dramatic reading with you. She's in chat. Oh, is she? I didn't see. Is she still here? Oh, if she's still here, I'm happy to bring her in. I wasn't ignoring her, or I was just kind of caught up in my thing. CC's been a member for 15 months. Glow T's an uncivilian. Happy Annie's been an uncivilian. Kilo Charlie Tango's gifted 10 gift memberships. She 3PO became an uncivilian. Ron Valkay became an uncivilian. Fat, Dumb, and Happy became an uncivilian. Al Dente became an uncivilian. Bird for $3. Stranded in Duluth became an uncivilian. Red Guy something said cops drove to the scene. They might have done it. Fair point. Maybe the cops did it. Michelle Leonard gave me a super sticker. Oh my God's Dana became an uncivilian. Scooter 54 became an uncivilian. And Jenanite Jen Ludford became an uncivilian. Okay, cool. Is Melanie still here? Is she still floating around? I don't see her in recent chat. If she pops back in, someone let me know. All right. I'll try to keep my eye out. All right. Thus, it was not dispositive whether a fact finder recanted the word acquit. Instead, an acquittals occurred if the fact finder, meaning the jury, acted on its own view the prosecution failed to prove its case. The ultimate question is whether the Double Jeopardy Clause recognizes an event as an acquittal. Thank you, Linda B, and thank you, Libra in Seattle. In making the determination, we ask whether or not to give operation state law. There's a ruling that the prosecution's proof is insufficient to establish criminal liability. Thank you, Flummox Alessi, for becoming a non-civilian. The Double Jeopardy Clause prohibits second guessing of an acquittal for any reason. Assuming it is an acquittal, then fair enough. The Cal-Andro case is a case that looks beneath the label, beneath the procedure to determine whether or not the substance defining the event, in this case, the jury decision, was an acquittal. The Cal-Andro case looks beneath the label, beneath the procedure to determine whether or not the substance defined. Okay. In Blueford versus Arkansas, the dissenting opinion, which, by the way, right away you're in trouble, because you're citing the dissenting opinion. It's like, well, that's not controlling law, so that's nice. In Blueford versus Arkansas, the dissenting opinion from Justice Sotomayor, but this was just a prelude to it, the context of her disagreement about whether or not they should honor what the jury foreperson said. Melanie Little's here. Outstanding. Let's bring Melanie Little into chat. That's fun. So I'm going to text her a link, which I have to create because I didn't set this up in StreamYard, but that's okay. We can bodge it. I have the power. I have the technology. So give me a second. We will make it happen. I am good with the tech. I can make it happen on the fly. I'm just that good. All right, great. Moving on. Let's see. What am I trying to do right now? Okay. All right. So first of all, I have to create a stream that she can join. So let's do that. All right. All right. So now I have a stream. Can I add in my own camera? That'd be good. Yes, I can. Outstanding. Okay. Now I need to create a link that she can join. Here's a link that she can join. Okay. Now I need to send it to her on Twitter. Let me do that. Is she on Twitter? Is she in my DMs? Melanie, you got to get in my DMs. Lol. Do I send to her an email? 50 gift memberships. Thank you. Does anyone happen to have Melanie's email address? Because she's apparently not in my DMs. She doesn't love me. She doesn't. Okay. So I have to send it to her in an email. That's fine. Email's fine. We can do that too. She's tied up at the moment? Okay, then this whole exercise is pointless. I hate you. I hate you all. She just texted me? Oh, okay, hold on. Oh, that's right. That's right. I have her phone number. I could text her. That's right. I have to go drive now, but I'll do it next time. Okay, thank you, Melanie. Melanie says she'll do it next time. Thank you, Melanie. I'll text her back. That's right. I have her phone number. I could just text her. Okay, cool. Smiley face. Great. All right, moving on. Calm down? I'm very calm. Finn in chat says calm down. I'm very calm. I'm just having some fun. I'm having some fun and frivolity. Is it not fun and frivolity hour? I thought it was fun and frivolity hour. Am I not calm? I'm hurt. I'm calm. This is happy Kurt. Happy Kurt is fun. Please don't rain on my parade when I'm happy Kurt. I deal with clinical depression. I deal with clinical depression. Please don't rain on happy Kurt. Don't take away my happy. I miss it so much all the time. All right, anyways, it says in ascertaining whether acquittal has occurred, form is not to be exalted over substance. We ask rather whether the fact finder has made a substantive determination the prosecutor has failed to carry its burden. Jurisdictions have different procedures respecting the announcement of verdicts and the entry of judgments, but the diversity has no constitutional significance. I suppose that's ultimately true. In the ultimate sense, it's true. Obviously, in the end, the Constitution wins, and procedure has to bend to the Constitution, so that's ultimately true. Jeopardy terminates upon a determination, however characterized, that evidence is insufficient to prove a defendant's factual guilt. Yeah. U.S. versus Martin Linden Supply Company, Supreme Court again said, development of Double Jeopardy Clause from its common law origin suggests it was directed as a threat to the threat of multiple prosecutions. At the heart of the policy is the concern that permitting the sovereign, in this case the Norfolk DA, freely to subject the citizen, Miss Reed, to a second trial for the same offense would arm the government with potent intimate instrument of oppression. Again, kind of like high-level stuff, right? America's cool, double jeopardy's bad, the Fifth Amendment rocks, but a little high level for what we'd ideally like. Yeah. The following comes from Green versus United States, an historic opinion on double jeopardy. The clause therefore guarantees the state shall not be permitted to make repeated attempts to convict the accused, therefore subjecting him to embarrassment, expense, ordeal, compelling them to live in a constant state of anxiety and insecurity, and most importantly, as well as enhancing the possibility that even though innocent, he or she may be found guilty. Fair. So the contention, Judge, here is that there was an acquittal. It wasn't announced, but Miss Reed is entitled to prove that. In fact, 4 or 5 jurors have come forward with no contradiction, are accurately representing what occurred in the jury room, and there was a finding of insufficient evidence, a finding to acquit her, and they should not therefore be subject to a second trial for murder. You know, it will genuinely surprise me to some degree if the federal court decides to go down this way. It will genuinely surprise me to some degree if they go down this way. Like, it is more likely, in my humble opinion, that the judge will simply say there's no manifest necessity and there wasn't consent. An issue that I don't necessarily agree with, but that seems more plausible. I don't really think they're necessarily going to go down this way because I don't think it makes any sense given the relevant law. Because there's no federal law that requires partial verdicts anyway, as we discussed in Blueford. And so even if all 12 jurors had come into the courtroom and said, we're not guilty as to 1, we're not guilty as to 3, we're hung on 2. Even if they had done that, as a matter of the federal law, there doesn't seem to be anything that precludes the judge from saying, well, that's not good enough, I'm declaring a mistrial. So I don't, if that's true, which seems to be true, then there's no reason to ask the juror because there's no point. So, you know. So the contention, Judge, is that there was an acquittal. It wasn't announced, but Miss Reed is entitled to prove that. Okay, all the rest of it. Why are courts so afraid of setting precedent? Oh, that's a really good question, and I'll tell you the answer to the question. Judges, especially conservative judges in particular, are concerned about setting precedent because we're very, very worried about what happens next. Right? Because we're very, very concerned about where that brick is being laid down, because we know that every brick that's going to be laid down from here on out is going to be laid down relative to that first brick, because that's how laying out bricks work, right? Once you put one brick down, where do other bricks go? Right? They go probably somewhere close to the other brick. That's sort of how that works, right? So the judges are really worried, or the conservative judges are really worried about precedent, because what they're really worried about is what happens next. What happens in all the cases for all of time, which is a lot of responsibility, right? They're like, okay, I'm going to make a decision. This decision may now influence every case that happens for the rest of time. Well, that seems like something I might be a little bit concerned about. You know, it might cause to my mind a little bit of humility. It might be, you know, maybe I should be a little bit cautious before I make a decision that might influence the rest of history. Maybe I should be a little cautious before I do that. That's why they're concerned. That's why they're concerned. They're worried about what happens next. Yeah. Caution and humility. All right. And that vehicle, if you will, the evidentiary vehicle to prove that, Your Honor, would be being the 12 jurors and anonymously outside the public, outside the media, and ask them questions you similarly ask a jury if you decide to determine whether it was a partial verdict, should I pull the jury. We don't have to intrude into the juror's mental process, why they've reached a verdict, what was the conversation that led to that verdict. Questions can be asked that would be outside the boundaries of Rule 606B, but even if we were at the boundary, even if it were a boundary, Judge Sarah, sitting in the First Circuit in United States versus Villar in 2009, said where there's an issue, and this was 15 years ago, regarding whether or not there's a bias against a Hispanic defendant, said the appellant's more powerful argument is the application of Rule 606B to prevent juror testimony about racial or ethnic statements made in juror deliberations is unconstitutional as applied, yet it violates the defendant's right to due process, which, fair enough. The rule obviously has to bend to the Constitution. So to the extent that the rule as applied would be unconstitutional, then the rule has to bend. That makes logical sense. I get that. Unintended consequences for days. Unintended consequences for days, my friend. Yeah. The lawyers have a saying, hard facts make bad law. Hard facts make bad law. What we mean by that is it's the really tough cases, the ones that really, really pull at your heartstrings, the ones that make you really outraged, that will make you make a decision that will wind up creating catastrophic effects. The road to hell is paved with good intentions, and so forth and so on. Yeah. So that's the problem. Could this set a precedent? It could. It absolutely could set a precedent depending on how this goes. It certainly could. Maybe Karen Reed will be the name of a case someday instead of just a person. Maybe it'll be the Reed decision, and we'll have Reed rights. Could be. Cases start that way. They often start that way. Cases start that way. And you'd be surprised sometimes the number of U.S. Supreme Court cases that have really banal beginnings. They have really banal beginnings. Sometimes it's just a really banal thing, and it just somehow winds up someday at the Supreme Court. It happens, man. It happens more often than you'd expect. Yeah, Miranda being a good example. Miranda was a guy, right? Miranda was a guy. His name was Miranda. That was his name, right? And, he thought that maybe someone should read him his rights. And he's like, geez, I wish someone would read me my rights. If only there was a name for that. But there wasn't yet because he was Miranda, so that didn't exist yet. Yeah. Oh, man. And so, yes, we're dealing with a different constitutional clause, but the reasoning is the same. You can't use an evidentiary rule to prevent proof of a constitutional violation. That's slightly overstating it, but technically correct. Yeah. And then, of course, in the ultimate irony of ultimate ironies, which is just one of my favorite details, Miranda, the guy, at a later time was stabbed and killed in a bar. Amazingly enough, he was not necessarily the greatest person. That you probably could have seen that coming to some degree. Miranda, the guy, was killed and stabbed in a bar, and they had trouble prosecuting the person who killed him because, wait for the punchline, they forgot to read him his Miranda rights. Yeah. There's nothing more important in Double Jeopardy Clause than the bar on mobile prosecution. And in this case, it cries out for some decision-making, Your Honor, in an area that hasn't had a great deal of decisions, in which there's no rule to prevent Your Honor from hearing the jurors making determination of whether or not the burden of proof has been met, whether the burden's on the prosecution, and whether the Double Jeopardy Clause, as they say, whether the burden is on us, the area they're trying to prove the jury, in fact, acquitted. The appropriate procedural vehicle should be a post-trial, irreliable voir dire. We asked Judge Cannon to conduct one within days of our end of the first jury trial and led to the decision against it in the Court of Appeals. But with all due respect to the courts that have correctly required voir dires when there's evidence of racial conversation in the jury, which obviously this isn't, and I submit a conversation and a Hispanic conversation, which is obviously isn't that either, the double jeopardy right is just as important and gets vindicated through the same procedure. You would like that to be true, which is where we determine what happened in the jury room. And that's where I go back to Zarneth, which had the language about when there's a credible abrogation of a constitutional violation. We have a duty to investigate. And I think consistent with that duty is the duty to investigate by voir diring the jurors. Alternatively, Your Honor could find, and the Attorney General will recommend, if you're going to do an order of voir dire, it could be done by Judge Cannon, which presumably makes the most logical sense. But I think it's perfectly appropriate to do it in this courtroom. That'd be funny. If Judge Cannon does it, but she does it in the federal courtroom, that'd be funny. That'd be weird, but stranger things, I suppose. It might be Judge Cannon's only chance to sit on the federal bench. So that sounds good. And then Your Honor would make credibility findings. Your Honor would determine whether or not there's any reason to be skeptical of declarations of the 4 or 5 jurors. And if there's no reason to be skeptical, then Your Honor would have a legal issue of determining whether or not a finding by a jury, a final decision by a unanimous jury, is entitled to stop the re-prosecution. See, you got that backwards, though. That's the thing, right? The judge has to make the determination that matters first. They're not going to bring in 12 jurors and ask the question and then determine whether or not the answer matters. That would be incredibly dumb. Why would any judge do that? That doesn't make any sense. They're going to make the decision as to whether or not it matters first, and then deciding whether or not it matters, then calling the jury. They're not going to do it the other way around. That doesn't make any sense. Oh, yeah, we don't like to bash other creators. We don't do that here. We don't bash other people. We want to keep it civil, and especially with respect to other creators. We don't tolerate that. So if people are being mean to other creators, then my mods have absolute blessing to remove that and time it out as required. We don't allow, it is literally rule 1 of the chat is like, be nice, I think is fundamentally like a rule. We don't allow that. So we don't do that here. So don't do that. Especially as it's personal. We might disagree with another creator, but we'll disagree with them for reasons that we'll hopefully explain, not personal, right? It's like, oh, I disagree. So I might say, like, for example, I agree or I disagree with Melanie about whatever, but it's not personal. It's just like we might have a disagreement. It happens. People think about issues differently sometimes. I know, it's amazing, but we don't bash people. That's not fun. Where's their fact-finding by the Superior Court, or for that matter, the Supreme Judicial Court, which I'm required to give deference? I guess 2 questions. Am I required to give deference? Which is a question that I also have, incidentally. So, for example, when the Supreme Judicial Court said that the judge gave sufficient consideration to all the alternatives, is that a finding of fact? And is the district judge stuck with it? The answer to that question is, I'm not sure. And also, the district judge also seems to not be sure. So they're also not sure. So I feel somewhat validated that, a sitting federal judge confirmed by the Senate also is not quite sure about this. That's like, it's nice to know we're on the same page about not being sure. You can bash Bev. I'd prefer that you do it in a more respectful way that's less personal. I prefer that you be like, I think Judge Bev is wrong, or I think Judge Bev is biased, or I think she, I prefer you do it but we'll allow a little bit more latitude with respect to the non-creator. So you can, try to keep it within some bounds of civility, I guess, but you can disagree with the judge. I often do. That's fine. Anyways, so Mr. Weinberg answers the question relating to the fact-finding issue. He says, no, I believe, Judge, that when we go to manifest necessity and the issues connected thereto, there are rulings of law. There are conclusions of law that there were no viable alternatives. Defense had an opportunity to object or find the ruling of law, that there are Factual records is the notes. Factual records perhaps the sequence of events that occurred, where you have note one, defense counsel and prosecutor, were provided an opportunity to read note one. They made an argument the defense wanted the two-week charge. The government did not. The second note, the state practice. The proper practice, reading the note to the counsel in the absence of the jury, hearing from counsel. In that case, the court decided to make it a two-week. I think those are all facts. I infer from those facts, recommend or contend the court should as well. The result of those two discussions is the demonstration defense wanted a verdict from the jury. I don't necessarily know that you can extract that from wanting to give the charge, but okay. My guess is, I know in my experience, my guess is the courts that when jurors say they're in an impasse after days of deliberation, many times defense lawyers ask for a mistrial, then they object to the Allen charge. Sometimes they do. Here we have the reverse. We have the government not wanting to give the Allen charge, although they didn't want the mistrial. They just wanted the jury to keep going. They didn't want the charge. We have the defense asking for the two-week charge, the state analog to the Allen charge because they wanted the case to conclude before this jury. They wanted a verdict. I don't know that necessarily is a fair conclusion. They wanted it to come to an end. They wanted the jury deliberations to stop. But whether they necessarily wanted a verdict, I don't know that you can infer that, but okay. Tammy in chat says, I learned a lot about law here. I appreciate that. Thank you. If you learn a lot about law, I'm doing my job correctly. And that makes me happy. That makes me happy. Let's see, where were we on Super Chats? I believe we were with Lynn Britton, member for 19 months. Always happy to be in the chat with you. Linda B became an uncivilian. Libra in Seattle became an uncivilian. Flummoxed Sally became an uncivilian. Watching the OnlyFan. Holla. We do love that hot OnlyFan content, don't we? We love that. We love how that fan spins for us, man. It's glorious. OnlyFan is best fan, man. I'm here for it. Mr. Fix-It became an uncivilian. Lady Zelda Kelly, nice name, became an uncivilian. Unbalanced Equation, gifted 10 gift memberships. And Unbalanced Equation has been a member for 3 months. With that hot globe, right? The hot globe in the hottest globes. Lol. And then we got Fire Alarm watching in the corner. Oh, yeah. No, we definitely ship courtroom objects. If this is your first time with us, yeah, when we're bored, we definitely ship courtroom objects. It's part of our charm here. That's what I'm going with. I'm going with it's part of my charm. Yeah, that's it. And for example, in the Murdaugh trial, we created a complete love triangle between chandelier, seal, and clock. With appearances by sconce and other elements of the courtroom. We had a whole love triangle. It was great. We were shipping it. We were writing stories. We were doing some shipping fiction. It was fantastic. You guys missed out on a good time, man. And then when you get to the third note, the practice of Judge Cannon was somewhat varied at Bannon. She didn't read the note to the defense and the government. All right, I think we're basically talking about manifest necessity. Yes, at least so far we are. The court, go ahead. The respondent correctly says the Supreme Court has no mechanical test, and any single factor does not dictate the decision. True enough. But what's true in this case, Judge, is that every factor the Supreme Court looks to determining whether there's manifest necessity, every factor weighs in finding of no manifest necessity. Not unreasonable. Was the decision made by the trial court made in haste? Was it precipiced? Well, yes, the time between the reading and the note, it was 30 seconds, and that 30-second issue is more an issue relating to consent for me than manifest necessity. But we'll get there if the court ever gets there. Until the jury came in, and then a minute reading the note to the jury, and then a meat decision sua sponte to declare a mistrial. That's precipitous. Second factor, the jury queried defense counsel before making a decision about their thoughts. Thank you, Carly, for becoming an uncivilian, by the way. We do appreciate it. We do appreciate all the people giving gift memberships and all the rest of it. That's very nice. We love you all. Okay. Second factor, did judge query defense counsel before making decisions about their thoughts and opinion, and there was no opportunity to give the defense counsel to read the note, to follow past practice, to follow state law, which requires, quote, a full opportunity to be heard. Fair. Third, did the judge give prosecutor bears the burden? The First Circuit says it's a heavy burden. Judge Ken did not ask the prosecutors what their judgment was, what their views were, where their opinion was as to whether or not the alternatives to declare a mistrial. Fourth, is there evidence the judge considered viable alternatives? And here there's no evidence in the record of the case demonstrates the judge consideration of any alternatives before declaring a mistrial. Also fair. And in this stage, what were those mistrials? Or what were those alternatives? Again, we have the state statute about what happens when a jury reports for the third time they're deadlocked effectively. What are the alternatives at the point? What are the alternatives at this point? Mr. Weinberg, I think she had 2 or 3 alternatives. The first alternative is to ask the jury whether or not there's a unanimous decision, a verdict, as to finding of any of the 3 counts. It was to read the note, not to conclude that there's no finding, which we now know inconsistent with the beliefs of at least 4, maybe 5 jurors, but that was a viable alternative. It was something the judge could have done. It was something the judge could have done. And there's certainly no evidence the judge considered it. That's fair. The advisory note to the rule, which is not dissimilar to the federal rule, says it's mandatory when you're going to order a mistrial. You have to ask the jury whether or not there's any partial verdicts. Okay, I don't like that at all. I don't like that argument, and I don't like it for a very technical reason. Okay? Whatever that note means is an issue of state law, period. Okay? It's a state-level rule. It's a state-level rule that says whatever it says, okay? So the rule seems to say may. The comment to the note seems to say must, okay? I appreciate that. I understand that. Now, whatever that means is a matter for the Supreme Court of Massachusetts and the Supreme Court of Massachusetts alone, because it's a state-level rule. The federal courts don't make state-level decisions. They make federal-level decisions. So whatever that rule means is for the state court. And the state Supreme Court didn't say, oh, geez, you didn't do the thing you were required to do, bad judge. They didn't say that. They could have said that, but they didn't say that. So the rule can't mean must, because if the rule did mean must, the Supreme Court of Massachusetts would have said, well, you didn't do the must thing. Bad on you. But they didn't say that. So the rule can't mean must. The rule must mean may. It must mean may. Okay, and the federal court can't do anything about that. All they can do is say, given that, that is somehow in conflict with federal law. But they have to take the state level law as a given. And I know that's a bit confusing sometimes. That's why I said it that way. I wanted to say it hopefully clearly, because I think people get confused on this point, because it is a bit confusing. But yes, the state level rule is the state level rule. And even the US Supreme Court can't change that. All the US Supreme Court can do is say, given that state level rule, taken as a given, there is a conflict with a federal rule, which of course the Supreme Court has the power to decide. That's what they do. So that's it. So I don't like you making this argument because it doesn't make any sense in a federal proceeding. To my mind, it doesn't make any sense. But intrinsic is the rule that allows partial verdicts as a court to at least consider, where that's more on point. It is an option. In fact, seeks some guidance from the jury as whether or not impasse relates on all or just a subset of charges. That was a viable alternative. That's a better argument. I agree with that. It was a viable alternative. It was an option. It was something they could do. Do you love? I love the Texas flag. Yeah, that's where I live. I live in Texas. Subtle clues. Yeah, subtle clues. Now you have a Texas flag. Is that because you're in Texas? Yes, as a matter of fact, it is. I live in Houston at the moment. All right, great. Watching from Germany. We love Germany too. Germany's nice. Federal can't overrule state rulings. They can't overrule state rulings as to their own state level law, no. No, they can't do that. No, they can't do that. The two-week statute says in the state 234 contains an alternative, which there could be no further deliberations unless a jury consents to deliberations. And so intrinsic in that is a court that has an alternative ask a jury whether or not they want to limit continuing deliberations to one or another accounts, or whether the note reflects an impasse as to all counts. Thank you very much, Yep, It's Me, for becoming an uncivilian posse, a higher membership tier. How very nice and generous. Appreciate it. Kelly Kell for 499 says, is it better for Karen Reed if manifest necessity is a matter of law? Well, ultimately it is. Ultimately, it's a matter of law, but whether or not there are factual components towards that is a bit of an open question. So it's better for her if it's a pure issue of law. It's better for her if she's not bound by the Supreme Judicial Court's finding that the judge considered all the alternatives. So that's much better for her. If the federal court is bound by that, I don't know how they can find manifest necessity. If they're not bound by that, they definitely can. Otherwise, it must be clearly erroneous. I'm on a 2L on your 2L on a memo break. Thanks, Professor Kurt. We welcome our 2Ls. Keep on keeping on, no problem. If your law school is looking for a professor, I'm available. Talk to the dean. I'm available. I'm pretty good at this, I'd like to think. I might be good in the classroom too. Let's give it a shot. Yes, if you're a dean at if you're a dean or a provost at a university and are looking for a law professor, ... The 2E statute in the state 234 contains alternative, which there could be no further deliberations unless a jury consents to deliberations, and so intrinsic is that the court has an alternative to ask the jury whether or not they want to limit their continuing deliberations to one or another accounts, or whether the note reflects an impasse as to all counts. Is my CV online? No, but if the school wants it, I'll be happy to forward it to them. The judge has a right to poll the jury and ask them the questions I request from the court as the post-trial voir dire. There are alternatives. None appear to have considered by Judge Cannon, who merely read the note and told the jury, I'm going to grant your wish, I'll be seeing you in a few minutes. I have to like cold. I'll figure out how to make it work. The court. Does that argument require I effectively ignore what happened with the first and second note, in other words? Is all we're examining what happened in isolation of the third note? Probably not. The dean is your advisor? Great. Well, I don't want to lob off. I think the court can consider history, but I believe that cuts in favor of several things. One is the defense wanted the verdict, which, did they or not, I mean, it's up for debate, to be honest. Two is the issue being discussed in the first and second note was not whether or not to order a mistrial, and therefore extinguish, or at least appear to extinguish, Miss Reed's double jeopardy rights, but whether or not to issue a supplemental instruction. The defense never asked for a mistrial. That's true, fair enough. The word mistrial was never mentioned in the discussion of notes 1 and 2, fair. And so everything in the dialogue regarding notes 1 and 2 showed the defense wanted the verdict, which is debatable. And moreover, it demonstrated to the defense what the practice that Judge Cannon was using, which is proper practice. The practice advocated in the state court is when a jury has a note, you read it to defense counsel before making decisions. You read it to defense counsel before calling the jury. It is definitely true that Judge Cannon did not follow best practice. That much is quite true. Yeah, if it's confusing and I help to make it less confusing, I'm doing my job. I'm doing my job. If I'm helping to explain it and make it less confusing and more approachable, I'm doing my job. Outstanding. Thank you. That makes me happy. So yes, I think Your Honor can consider that, but I don't think the interactions provide a basis for determination of manifest necessity or a basis for inferring defense would not object to a mistrial or they want a mistrial. I think it just infers the opposite. Well, I think you could just kind of go with, they didn't even give him a chance and it wasn't considered. I don't really think you need to make this argument. I don't really think it gets you anywhere. I don't think it gets you anything more. I don't really think you need it. It's like they never asked and it was never mentioned, and it's like what the defense sort of wanted in their own mind is sort of neither here nor there. They never gave the defense a chance is more to the point. Do you say it with an E? Canoni? It's Canoni? Okay, fair enough. Judge Canoni. No intended disrespect. I apologize to Judge Canoni. I apologize. Yeah, I'm sorry. Sorry for making a mistake on your name. Judge Canoni, I apologize. It's Canoni like macaroni? Fair enough. So the Supreme Court also talks about precipitousness and whether or not each party was given an opportunity to register their views and whether the court considered viable alternatives, where the judge made findings. Again, not one of those are absolutely mechanically required as a precondition to either a mistrial order or reversal. So none of them are necessarily required, but the failure to do any of them might be a problem. Also, whether the judge gave consideration in weighing the central values in the defendant of having the right to avoid successive prosecutions is another factor the Supreme Court weighs, and here there was no consideration evidence in the record given to Ms. Reed's fundamental constitutional rights not to have go through this ordeal a second time. And as Green said, not to face the risk that an innocent person being re-prosecuted could well face a second jury. Having to win twice is a very different thing than proving not guilty once. But the first, yeah, I mean, that much is true for sure. I mean, you never know what's going to happen with any random jury. That much we know. There might be an opinion soon in the University of Oklahoma. The prosecutor in the glossip is an adjunct. Apparently students are trying to get him out after the Supreme Court opinion. That's hard. That's funny, man. That's funny. Oh, man. But the First Circuit jurisdiction, I contend, is even clearer regarding what required as condition precedent for declaring a mistrial. It starts U.S. versus Ramirez, and all those cases cited in our petition. It says, quote, in U.S. versus Pierce, which is a 1979 First Circuit case, we held that's a holding. The determination whether there's a manifest necessity for mistrial, our first inquiry must be whether the court gave adequate consideration to the existence of less dramatic alternatives. Christina McVeigh for 999 said, excellent explanation of federal law versus state law. I'm in no way a lawyer involved in law. However, completely logical. The federal judiciary has no influence on the state judiciary law. Superb explanation. Right. Separate sovereigns, baby. Separate sovereigns. Welcome to federalism. Federalism and you, the continuing discussion. We split the atom of sovereignty. We split the atom of sovereignty, and we've been dealing with that reality ever since. It leads to all kinds of fun and exciting complications. It's a good thing, man. Years later, in U.S. versus Turbillo-Lugo, the court said, where there's a viable alternative to a mistrial, what class would I like to teach? What would I like to teach? Federal constitutional law would be the best. That's the thing I know the best. That's the thing I'm the most expert at, is federal constitutional law. That's the thing I know the best is federal constitutional law. Federal law in a broader sense is the thing I know the best. That would be nice. I'd like to teach federal law. Constitutional law would be preferable. That's where I live. That's my happy place. U.S. versus Canola Santana, another 2022 case, is the same. At the very least, quote, we require the federal district court to consider other options to ensure a jury is generally deadlocked before discharging it. And my fourth case, which is a panel from 1981 that was shared by Judge Wazinski. I'm old enough to remember Judge Wazinski's tenure on the district court and Judge Breyer. Justice Breyer sitting in the First Circuit 1981, whether or not the record indicates the trial court has considered alternatives to a mistrial significant. Fair enough. Could I argue this on appeal? Sure. Yeah, either way, I could argue this on appeal easily. The Commonwealth's argument, I think, is the easier argument. But I would have no problem ethically arguing either side of this, because they're both very ethically tenable. The Commonwealth, the defense is trying to do something novel. They're trying to do something new. So they're in an inherently underdog position. There's nothing that says they can't do what they're trying to do. They're just trying to do something new. And, underdog is kind of fun. even if you expect to get your teeth kicked in. And obviously the Commonwealth seems to have the better end of the law, so that's easy enough to defend. So I could defend either side of this case because the law is, it seems fine to me. Also, the major importance of affording counsel an opportunity to be heard. A precipitous decision reflected by rapid sequence of events, thank you Alabama Rose for 10 gift memberships, culminating in declaration of mistrial would tend to indicate insufficient concerns for defendants' constitutional rights. And that panel properly said a trial court must temper a decision whether or not to abort a trial by considering the importance to the defendant of being able once and for all to conclude his confrontation with society through the verdict of a tribunal he might believe to be favorably disposed. The Brady case, and it was a habeas case, Brady versus Sama, it included two other procedural points. One is the burden on the Commonwealth, not on the defense, to justify reprosecution. That much is true. Neither of the state courts put that burden on the state when making the trial court's opinion the Supreme Judicial Court opinion. And second, that although there's some deference to the trial court, discretion, that deference is extinguished when the record of the case does not demonstrate a sound and careful exercise discretion such as we did not occur here. Yeah, I think manifest necessity is the easiest one for Karen Reed to win on by far. Yeah, that's the easier one for her to win on. As long as the court's not bound by that Supreme Judicial Court decision or finding. As long as they're not bound by that, then she wins, I think, on manifest necessity. That's not the problem. Excuse me while I get just a drink of water real fast. Throat is getting just a touch dry. Water is tasty. Okay. The court, to the extent that the First Circuit cases like Tabir or Ligo written before the Supreme Court decision in Rinko and Blueford, if they can't be harmonized with Rinko and Blueford, do you agree they're superseded by Rinko and Blueford? So in other words, to the extent they suggest there's a checklist, you must do one or two or three things. There is no checklist, and I think Rinko at some length says there's considerable deference is given to the trial judge. I think that's right. I don't think there's any checklist. Rosemary G for $10 says, or nothing, she just gives a thanks. Thank you. Mr. Weinberg, and two answers to that. Rinko, of course, was a 2020-54 case, not a 2241 case. The court. Let me pause you there. But for 2254 cases, there's a two-part inquiry. Was there clearly established federal law, paraphrasing the statute, clearly established federal laws established by the Supreme Court, and then was the state court decision unreasonable in light of that? So a very differential standard, which is not applicable here, yes. But on the first part of the inquiry, was the clearly established federal law that does apply here, right? Yes, Your Honor. This is federal law. Yes, that's why I said the Supreme Court, and including Renico, did not have a mechanical test, but it doesn't conflict with the First Circuit. And the First Circuit decision even said there was no mechanical test. They said it in the First Circuit decision. So the First Circuit doesn't disagree. There is no mechanical test. They simply said, here are three factors that you can use. It doesn't necessarily mean that, that's dispositive, because if it did, that would mean it's mechanical, which it's not. So, the failure or success of all three factors doesn't necessarily tell you anything. But, here's some factors that you can muse on. So fair enough. So I'm not arguing there's a mechanical test in the First Circuit, which there's definitely not. I'm arguing that each of the principal four factors looked to by a series of First Circuit decisions. Were there viable alternatives that were carefully considered? No. Was either counsel given an opportunity to be heard? No. Was the decision precipitous and made in haste? Slightly more debatable, but I think yes is the better end of that argument. And more important, was there any evidence in the record of careful consideration of defendant's constitutional right as protected by a Double Jeopardy Clause not to be subject to re-prosecution? Not a word in the record of the state's court. Fair. So that the Supreme Court, they said, you look into multiple factors, but Arizona versus Washington says you only give deference. You only apply abusive discretion standard when there's demonstration of exercise of careful discretion. That goes back to a careful called Perry Perez, which is an ancient U.S. Supreme Court case, which talks about urgency. It talks about, how important the double jeopardy right is and how it only gets extinguished when there's essentially no other alternatives. And here I recommend that there's just no demonstration that the Judge Canoni believed there were alternatives to be considered. She made a mistake. She misunderstood the jury note if 4 of those 5 jurors and the first one reported the mistake the very next day are correct, and therefore there was no manifest necessity for the declaration of 2 or 3 counts. I'm not sure it comes down to whether or not she understood the jury note correctly. Because even if she had understood it to mean they were hung as to some counts, but not all, right? If she did understand to mean they were hung as to some counts, not all, there's nothing in the rules that requires her to ask for partial verdicts. And there's certainly nothing in federal law that requires it. I can do online classes regarding different cases of federal law. That would be cool. Well, to some degree, what do you think I'm doing now? What do you think this channel is to some degree? But yes, I appreciate that. Thank you. The state says, well, it would be coercive to, for Judge Canoni to ask the jury any questions once they deliver the note. But there's nothing coercive about asking the jury whether or not the note relates to all counts, whether or not their decision, they're at an impasse includes all counts, whether or not they have a decision on any counts. I don't know that I go so far as to say there's nothing coercive about it, because even the question is sort of like, come on, really? You can't find anything? So I don't necessarily know. I don't necessarily I wouldn't go so far to say there's nothing coercive. It may not be coercive enough to care about, but there is some potential coercive effect. Judge Bev will not dismiss. I agree completely, but we're not in Judge Bev's court right now, so let's talk about what we're into. Let's talk about what we're talking about, right? The cases relied on, including the state court cases, were all single count charges, not mobile count charges. When you have Rule 27B, or in this court 31B, it's inherent that if we're going to determine whether there's a partial verdict, if we're going to, see, again, it's permissive language. A court has the power to ask a jury in a non-coercive fashion whether or not they've reached a consensus and a unanimous verdict on any one count. Had she done that, it's predictable and probable the jury would have said we're an impasse on count 2, and it's a failure of the judge to ask that jury respectfully to Judge Canoni, who's an expert state court judge. Why is it a failure? Why is it a failure to ask that question? That has not been established. She made a mistake. She should have consulted counsel. She didn't consult counsel. That much more is on point. There's no evidence here counsel consented to a mistrial by asking for the Tuohy-Rodriguez instruction, which she found in her opinion, but the Supreme Judicial Court did not apply or rely on any allegation of consent, which I still think is a bigger issue relating to consent. And I think the posture of this case is a little bit different than it might otherwise be because that Tuohy-Rodriguez charge was given. All right. So there have been cases, and including cases cited in this petition, where judges have basically said, oh, I'm just declaring a mistrial with no particular indication at all that that's what's happening. Right? They've just kind of out of the blue said mistrial time, and everyone's sort of left flat-footed. At least in my humble opinion, that is not this situation. Because that Tuohy-Rodriguez, or if you want to call it an Allen charge, because that's what the federal courts would call it, but the Massachusetts wants to be different for some reason, that charge, right, is sort of the last step. It's the dynamite charge. And so I do take exception to the idea that the defense didn't know mistrial was lurking in the air. I do take exception to that. No one may have said the word mistrial, but the charge was given. And every lawyer knows that once that charge is given, either the jury's coming back with a verdict or they're not. And either way, we're all going home, except with the possible exception of the defendant, who may or may not be going home, depending on what the jury comes back with. But everyone else is going home. Right? So I do take some exception to the idea that they were completely blindsided by the judge's declaration of mistrial. It's like, If you didn't know that that was a possibility in response to a jury note, any jury note, at that point, I'm like, you're just not paying attention. So I don't buy that one. I really don't. So that's just me. What we have here is whether under the Supreme Court factors, which admittedly are not mechanical. And again, Blueford is distinguishable. I'm not sure it 100% is, but okay. And the dissent that I read to the court did not dissent without holding a Blueford is a case that demonstrated the importance of finality. They even talked about, if I can find it on this blizzard paper, if your honor would give me a second. They talked about the Blueford case that they're relying on, the lack of finality of judgment, rather than, whether or not the judgment had to announce it in any particular formal way. Yes, but of course, in that case, the jury literally said we're not guilty, and then they kept deliberating, which means it wasn't a partial verdict and sort of implies partial verdicts are not required. The Bev is letting the fake doctor testify. It'd be interesting to see why she's letting the fake doctor testify. It'd be interesting to see if she's saying because she made a mistake was saying that the expert needed to be an MD. Because I didn't think that made any sense in the first place. And so if the judge is simply correcting the error and saying, well, I shouldn't have said that, that was a dumb thing to say, and so this person can testify, then that makes more sense to me. So it'd be interesting to see why the judge said it. But that's not what we're doing right now, and I'm not going to rabbit hole it right this second. Anyways. Excuse me. So there is, it says the four-person report prior to the end of deliberations lacked the finality necessary to amount to acquittal of those offenses, quite apart from any requirement the formal verdict be reached. I contend there's nothing inconsistent in Blueford and nothing inconsistent in 2010, 2020 54 case that Renico and Lett is inconsistent with the First Circuit jurisprudence if the First Circuit continuous jurisprudence is read as a multi-factor test. As long as it's not exclusive, I think that's fine. Here, none of the factors weigh in favor of the mistrial order. I tend to agree. I don't have to rely on just the lack of consideration of a viable alternatives, just a lack of an opportunity for defense to be heard, just the absence of any evidence in the record that double jeopardy was considered. Here, all the factors weigh in favor of federal court reversing the state court decision and finding jurisprudence of this circuit, which includes jurisprudence in Brady and a 2241 case compels a judicial determination. There's no manifest necessity. Manifest necessity is important. It wasn't necessary. It certainly wasn't manifestly necessary for that trial court to sua sponte declare a mistrial without hearing from counsel, without considering alternatives, and without weighing Miss Reed's double jeopardy rights. Thank you, sir. Thank you, Mr. Weinberg. Let's take just a moment, stretch our legs, and I'll hear from the Commonwealth. Good advice for us all to take a break. If I'd been arguing this appeal, how did I make my argument? Well, if I'm arguing for the Commonwealth, I'm probably arguing more about the issue of consent, probably. But we haven't heard from the Commonwealth yet. We've been hearing from Miss Reed's lawyers. So if I'm the Commonwealth, I'm probably hammering consent. And if I'm Miss Reed's lawyers, I can't think of any better way to do it than they're doing it. The way they're doing it is probably the best way to do it, because consent doesn't seem to really work for them. So I'd be talking about manifest necessity and hope that works. That's what I'd be doing. Lawyers elevate arguments that are good for them and they diminish arguments that are bad. They elevate facts that are good for them and they diminish facts that are bad. That's sort of the fundamental role of a lawyer, in short. Let me heighten and elevate what's good for me and sort of bury and, get you to ignore what's not so good for me. That's sort of the fundamental role of a lawyer. You said yesterday you want to see why consent was not part of the transcript. Is it in the transcript? I don't know. I haven't finished the transcript yet. I'm reading it along with you. We're getting towards the end of the page, though. We're getting towards the end, and I haven't discussed it yet, so it doesn't look like it's coming up, but I don't know. We haven't gone that far. I'll get back to you. All right. Mr. Schlinger, for the Commonwealth. I'd like to start by addressing Your Honor's question. There were factual findings made here, Your Honor, both by a trial judge and the Supreme Judicial Court that are significant. I'll try to address those in the context of specific issues we're talking about. Those factual findings are owed deference in this habeas action, as set forth in the Marshall case that we cite in our brief and also reaffirmed later by the First Circuit in Powell v. Tompkins. Importantly, Your Honor, there are also determinations of state law made by the Supreme Judicial Court in opinion below. They're also binding in this federal habeas action. The court, I agree they're binding. I'm struggling with how they intersect with federal habeas law. You and me both, Your Honor. You and me both. We're both a little unsure. Yes, Your Honor, and I'll try to weave that into the context of the mistrial or acquittal or the post-trial inquiry. I do have one example just to preview on the mistrial issue. Petitioner continues to argue based on reporter's note to Rule 27, Massachusetts Rule of Criminal Procedure 27, that some sort of inquiry of partial verdicts is required or mandatory. The Supreme Judicial Court flatly rejects that argument, knowing it's discretionary, and as a matter of state law, that is definitely the end of the game. That is the end of the game that far. When undetermined as a matter of state law, making such an inquiry would be improperly coercive. Those determinations cannot be relitigated here. I agree they can't be relitigated here. That's a state-level determination as to its own state-level law. Those determinations cannot, in fact, be relitigated here. That is correct. So turning to the first mistrial issue here, and manifest necessity, as Your Honor noted, we have clear Supreme Court precedent here, as there's no required checklist the judge must go through before declaring a mistrial. That's true. She's not required to go through any particular checklist. She's not required to do any particular thing. But if she doesn't do everything, that's a problem, right? So is she necessarily required to ask the lawyers before declaring a mistrial? No, not at least according to the Supreme Court, they're not, right? But if the judge fails to do anything on the list, well, that's a bit of a problem. So they're not dispositive, but yeah. She's not required to 999 from Christina McVeigh. I need to clarify my position here. Karen Reed is being persecuted and wrongfully prosecuted by the state's corruption. Except for the grace of God, we all sit as defendants commit crimes. That's fair. That is fair, right? And I think the evidentiary issues for Karen Reed are ludicrous. I can't believe the state is prosecuting this case with these evidentiary problems. There are just so many of them. It is laughably absurd. It's a farce. The whole prosecution is just a farce, man. You have to laugh so you don't cry. That's where we're at. We're laughing so that we're not crying, man. It is just a complete and absolute farce. The evidence and the collection of the evidence and the logs and the solo cups and it just goes on and on and on. So yeah, I agree with you that this case leaves a lot to be desired for the Commonwealth. It's a disaster. It's a disaster. As Your Honor has also noticed, the discussion of what federal double jeopardy jurisprudence does or does not require in Renico was based on federal precedent, separate and apart from the application of precedent under the deferential standard of 2254. I'm not sure that I agree with that either, but that's fine. How's the farce stop? Why is there any recourse for this? Well, there is recourse. But whether or not that recourse, there is recourse. But, someone has to make a decision. And it's like, well, there's, no one promised you, utopia, unfortunately. So, there is recourse. She has the right to appeal. There is recourse, but, sometimes people who are wrongfully accused get convicted and they serve time in jail. And that's just the reality of the thing. It's not all wishes and rainbows. Welcome to the real world. You put in all these protections in hopes it doesn't happen, but there's nothing that prevents it. fundamentally. Like, how could you even prevent it fundamentally in theory, right? We're human beings, man. We do the best we can. Or at least we try to. We're all mad here. Gifted 10 gift memberships. I'd like to believe the trial judge is doing the best they can, although that's getting increasingly hard to believe. Watching how she treats the defense versus how she treats the prosecution, it's getting increasingly less tenable. Trying to find a neutral way that Judge Cannoni is treating the attorneys in a neutral manner. It's getting increasingly difficult to find a rationale for her behavior from first principles. Yeah. Is my eye okay? Sometimes I have allergy attacks. It happens. We'll press on. Sometimes I have allergy attacks in my eye. It happens. As your honors also noticed, the discussion of whether federal jeopardy jurisprudence does or does not require Renico was based on federal precedent. To the extent there's any lingering uncertainty about that, I would point to the court to footnote 2 in Blueford, also referred to by Chief Justice Roberts, where he notes the dissent similarly tried to distinguish Renico on the grounds it was habeas and, quote, has little to say about trial judge responsibilities, but also went on to note Renico's discussion of the applicable legal precedent principles concerns just that. So that discussion's on point, Your Honor. It's binding, and that makes clear there's no set checklist here. Massachusetts law, in comparison, arguably imposes a more exacting standard, as it does require a trial judge to explore alternatives to a mistrial and give counsel a full opportunity to be heard. I'm sorry, can I get you to move get in a little bit closer? Certainly. Just on the last point to repeat, Your Honor, Massachusetts law does arguably impose a more exacting standard. It does require judges to give consideration to alternatives and to give counsel a full opportunity to be heard, but the Supreme Judicial Court found as a matter of Massachusetts law, the trial judge here did that. She considered alternatives, namely in response to the first note. She simply didn't declare a mistrial or rush to declare a mistrial. She rather encouraged consensus and tries to encourage jury to reach a verdict by instructing them. And again, as to the Massachusetts state law, the determination of the Supreme Judicial Court of Massachusetts is dispositive. So, this is the part where you guys get a little frustrated, I'm sure, and the part where I don't really have any answer. I don't really have any answer except to say it's the way it is, which is not what you want to hear. I know. But look, Massachusetts law says the judge has to give alternatives to consideration alternatives. It says that counsel has to be a full opportunity to be heard. But then the Supreme Judicial Court found as a matter of law, the trial judge actually did do that, which is the end of the game because it's Massachusetts law. As far as the Massachusetts law goes. So maybe it's what we call a parchment guarantee. It doesn't really mean what it says on the page. But that's the Supreme Judicial Court's call. If you don't like that, I suppose you can go to the legislature and get them to change it. But that's that. So that's depressing. Moving on. And then you move on to the Constitution. Well, we're looking for federal law, not necessarily the Constitution, but we're looking for federal law that conflicts with the state level decisions or we're looking for federal authority in the federal court. So the state level authority isn't going to help you in federal court. We need federal level authority. So, It was only when the third note arrived containing even more emphatic language yet and made clear, Your Honor, the jury was deadlocked on all charges, would not consent to further deliberate, and if they were forced to continue to deliberate, any verdict that they might reach would not be a just judgment, but rather would be the production of compromising their deeply held beliefs, which is exactly what Tui Rodriguez tells the jurors we don't want you to do. It was at the point she declared a mistrial, and I think significant the trial judge found she had no doubt based on the jury's 3 notes they were unable to reach a unanimous verdict, and there was no, quote, inkling of agreement as to any of the charges anywhere in the notes, which, to be fair, there wasn't. I mean, at best, there's slightly ambiguous language. I mean, the reading of the judge's note is not unreasonable. And the Supreme Judicial Court similarly found, Your Honor, that based on the record presented, nothing suggests the deadlock was limited to a specific charge. On the contrary, the note contained no inkling of agreement, and the third note implied the jury was deadlocked on all charges. Interesting here that the Attorney General for them isn't arguing that as a matter of federal law, they don't have to do partial verdicts. That would be the argument I would make here. I think this is not making the right argument. I would actually make the stronger argument. I'd make the argument that as a matter of federal law, they're not required to do partial verdicts, and so it doesn't matter. But the Attorney General is making a weaker argument, which is strange to my mind, but okay. So looking at the circumstances that would inform the judge's exercise of discretion and declaring a mistrial on one side of the scales, there was no need or reason for it to go farther and inquire the jurors. In her mind, as the Supreme Judicial Court found, there is no indication here there might be partial agreement as to some of the charges. At the same time, Your Honor, the jury made it clear, and the judge found it was clear to her, they wouldn't consent to continue deliberating. So under Massachusetts statute, they are precluded from being ordered to further deliberate. On the other side of the scale, there were strong reasons that militated against making any sort of further inquiry, including the alternatives that the petitioner continued to suggest, which were very real and evident prospects of improper coercion, as the Supreme Judicial Court found. Prospects hard time. For $5 says, Weinberg surely knows all your arguments, so why bring the petition? They can't even mention coercion by foreign person who prevented the notes for Bev. Well, they're trying to create something new. They're trying to create new law. They're trying to create new law. You know, they're in a weak position. They're in a weak position. At least in my humble opinion, they're in a weak position. But, you know, there's nothing that precludes their position. It's certainly non-frivolous. It's not a frivolous position. There's nothing in law that precludes the position. There's nothing that forecloses it. So it's not frivolous. It's just a weak position. You know, so they threw a Hail Mary. Maybe they get lucky. There also is defense and strategic considerations, Your Honor, which is something the trial judge explicitly noted in order denying the motion to dismiss. And the Supreme Judicial Court also found in footnote 12 of its opinion, which is the trial judge of their own accord to start making the sort of inquiry runs the risk of extracting a guilty verdict as opposed to mistrial across the board, and competent defense would not want the judge to make such an inquiry and result in that risk. I suggest that consideration was all but stronger here in this case, given the nature of the petition defense, Your Honor. This wasn't a case where petitioner had different discrete defenses to different charges. That's true. Her defense across the board is what she did not cause the death, but supposedly had been framed. If the jury were to come back with a guilty verdict on any three charges, or lesser to include defenses, they would have necessarily found that she did cause the victim's death, and would be a rejection of that defense in the public narrative. Taking into consideration those circumstances on the one hand, Your Honor, there was no reason to make further inquiry. There are very strong reasons not to do so, namely, the prospect of improper coercion, defense strategic considerations. It wasn't an abuse of discretion here, and the federal constitutional law does not require a mandate the judge plow forward with such an inquiry on the face of determination. It doesn't require that they plow through with the inquiry. He's misstating it, and I think he's doing it deliberately. Right? No one is necessarily saying that they have to proceed with the inquiry, although maybe the defense is, but whatever. I don't even think they are. But the bigger issue is whether or not she has to consider it. And that consideration can be like, I'm not doing it. It can take all half a second. It can be like, well, I could technically do it, but no. And that would be enough. But there's nothing that indicates even that much. And of course, it is on the Commonwealth to prove that element. They're the ones that have to prove manifest necessity. So they're trying to kind of do it implicitly from the other notes, which, you know, maybe you can get there, but, you know, that's not necessarily great for them either. The court. Well, I think that's one of the complicated questions here. That is, I'm required to accept the Supreme Judicial determination of Massachusetts law. That's final. I can't revisit that. Good job, federal judge. You're right. You can't. To the extent there are factual findings, I'm required to give deference to them, but I can revisit them under appropriate circumstances, and federal law ultimately I address de novo. How those things interact with each other and how the Supreme Judicial Court's findings affect my decision is somewhat fuzzy to me. And the fact the judge says that makes me feel very validated, right? It's like I always feel validated when I'm confused and the judge is confused, or I feel validated like when I'm saying something and then the judge says something, right? That's like, it's like, oh, okay, I'm not a moron. It's like, I'm not a moron, right? It's like you always feel a little bit validated when you're like, I'm confused, and the judge is like, I'm confused too. And I'm like, great. At least we're both confused. I feel better about my own intelligence and ego now, right? So we're both a little confused. That makes me feel good. The Supreme Judicial Court says it's all appropriate under state law, whatever the statute or Rule 27, perhaps the Massachusetts Declaration of Rights. I can't remember whether it's an issue or not, but regardless, it didn't violate Massachusetts law. To what extent does that inform or not inform my decision? Mr. Schillinger, the way I view it, Your Honor, I think about that is there's a type of custom or practice in federal court to make the sort of inquiry or take these additional steps. Forget about the voir dire, the additional fact-finding. I'm sorry, Your Honor, correct, exactly. When the jury comes back and says we're deadlocked, there may be a custom or practice in federal court to individually inquire of the juries. Are you truly deadlocked, or can you come to agreement or any sort of charges, which is what the petitioner is suggesting should have been done here. But when the state court has looked to under state law and said it would do so, improperly coerces a verdict, and significantly because that's something that protects defendants as well, Your Honor, right? If the judge were to do that and the judge came back guilty, just as the Supreme Judicial Court, the petitioner would be making very strenuously and potentially meritorious arguments. It was improper for the judge to do that. And I think they're right. The Commonwealth is right. You know, in some counter, like you have to remember you don't know what you don't know, right? And you have to remember when you go back in time to remember what you knew at particular times, right? So the defense knows now the jury would have said not guilty. But I bet your bottom dollar, right? I bet your bottom dollar that in some sort of counterfactual world where 5 members of the jury came forward and said, no, we were unanimous as to guilt as to count 1 and 3. We were just a little unsure as to count 2. We were deadlocked. 8 votes to acquit, right? So flip it all on its head. Flip it all on its head. Yeah, we were guilty as to count 1 and 3, but we were a little unsure as to count 2. We had 8 votes to acquit. You know, you can bet your bottom dollar that in this counterfactual world, the defense would have been like, yeah, they should have pulled the jury. I wish for sure we would have known that, right? I wish for sure that, you know, that we had pulled the jury. It's bad judge for not pulling the jury. That was something you were required to do. Why didn't you pull that jury and get those guilty verdicts on the record? That was a bad thing to do. I mean, obviously, right? Duh, right? So it's like so the defense to some degree is cheating. They're cheating. They're cheating because they know the answer now, and that's cheating. You can't do that. You have to go on what you knew then, right? If the judge had said, do you want partial verdicts? Do we really think the defense would have said, yeah, we want partial verdicts? I don't think they would have. They say they do, but I don't think they would have. I think that they're lying. I think they're lying, or maybe telling a little white. Yeah, we totally would have asked for partial verdicts. We just weren't asked, Your Honor. Yeah, you're saying that because you know the answer now. That's cheating. You can't do that. That's cheating. And incidentally, by the way, like the juror's mind is not something that is not relevant to the judge's decision, because obviously the judge didn't know that. So if the judge made an error, right, it was in failure to ask, not because the jury secretly thought something, because how would the judge possibly know that? So how could it be an error? Except it's to the failure to ask, right? Okay. Federal practice might be different. It might be a different custom where it's typically done. But in the absence of a clear constitutional command, the Double Jeopardy Clause requires before declaring mistrial, based on jury deadlock for manifest necessity, you must take the following steps. I think the Supreme Judicial Court's determination under state law, it would be improper to do that controls. Yeah, but the thing is, the failure to consider it might be the problem. Right? Not the failure to do it, but the failure to consider it. That's how I think of it or view it, Your Honor. I think with all these issues, it's a question of what does the federal constitution require or mandate under these circumstances? And certainly as to that, Your Honor, review is de novo or plenary. State law obviously cannot impose a requirement that runs afoul of the federal constitution. That much we're very clear on. We're not suggesting that, but we're suggesting the Supreme Judicial Court's determination of state law should be controlling here, absent clear command, which is not necessarily an unreasonable thing to think. The court, okay, continue. Mr. Schellingler. Unless Your Honor has any other questions concerning the issue of manifest necessity, I'll switch to the alleged acquittals, and here there are 3 Supreme Court precedents I want to point out. 2 have already been mentioned by counsel. One is McAlrath, which is significant because it acknowledges that in deciding or determining whether a jury acted on their view the prosecution failed to prove a case, the determination is informed by the operation of state law. Certainly where a jury has returned a verdict of acquittal and it's been accepted by the trial judge, and I accept, Your Honor, because Justice Alito's concurrence where he knows there may be situations where a trial judge refuses to accept inconsistent verdicts and sends the jury back to further deliberate, which was just, Blueford all over again. And the court hasn't spoken about whether that runs afoul of double jeopardy or not. Yes, they have. That was Blueford. But where the verdict was returned and accepted of acquittal, it's inviolate. It is an acquittal, and it can't be thrown out or set aside on grounds that may be inconsistent with other verdicts, which was the issue with the repugnancy doctrine under Georgia. We don't dispute that, which is a good thing not to dispute because you'd be an idiot. Kamichi becomes a member for 5 months. I really do appreciate, by the way, all your support and your super chats. It makes a huge difference to me. I really appreciate it. I'm going through some minor economic stress at the moment, and I appreciate it. And not the least of reasons, I'm trying to lose weight, and it's very expensive for the medication I'm on. And so your super chats and contributions and support makes a big difference. And as I mentioned before, I deal with depression. And so your presence here makes me happy. Thank you for being here and spending time with me. It makes me happy. I feel validated. Your love goes a long way too. So in addition to your money, your love also goes a long way. I do appreciate it. Thank you. So similarly, there's no question the labels are not dispositive. So in the case of judicial action or ruling, it doesn't matter that state law might characterize a particular action as procedural if, in fact, a determination of the merits of the prosecution failed to prove its case, that's an acquittal. But neither of those goes so far as to suggest that in the first instance, the state cannot prescribe what constitutes a final ruling or determination by a jury, and that's the crux here, which isn't. Yeah, as to that, I think that's fine. I don't really see that. I don't see the case turning on this. I see it more turning on manifest necessity or consent. That seems to be more the thing that turns on to me. And the third case, which I'll skip to because it's important, wasn't mentioned by counsel, is Smith versus Massachusetts. I direct your honor to discussion on pages 470 to 474. This is a case petitioner cites. The court specifically notes the state can impose a rule of non-finality, that judgment of acquittal or directed verdict is only tentative and can be reconsidered up until, for example, it's signed and entered on the docket or a formal order has been issued. Fair enough. Orthan methodology for $10 from a fellow Houstonian. Thank you for that super chat. And if those of you who are in Houston, you ever want to try to meet up or something, send me an email. My email address is in the video description. If you want to meet up, maybe we can meet for lunch or something. It might be fun. We have some chicken wings. Chicken wings are fun. Yeah, get weight loss meds through Bright Meds for $200 a month. I've looked into multiple options with these things, and no. Not really. It doesn't really turn out that way. Like the $200 a month thing for all those ads is a price for like the least potent compounded medication. I was looking at one recently where I was looking at a service, and for the same equivalent, it would have been $450 as opposed to $650. But then I still have to pay a monthly membership fee of like $60 or something. So now we're up to $510. And so it's like, well, I mean, I could pay that versus $650 and save $140 a month. So maybe, but it's not exactly the massive cost savings that some of the ads would have you believe. So there's that. Cyber Sleuth staff for $10 says, thank you for offering all your expertise. How much do I usually spend on it? $650 a month. It's expensive. So the particular issue in this case, Your Honor, was a judge granted a motion for required finding of not guilty because the prosecution had failed to prove or introduce evidence a firewall had a barrel less than 16 inches. Is that with insurance? That's with a coupon. My insurance doesn't cover it. I couldn't find, incidentally, any insurance that covers it for weight loss when I was on the exchange. I looked, actually, to try to find an insurance that covered it for weight loss on the exchange. I couldn't find one. Couldn't find any insurance that covered it. Upon being given further, case law authority by the prosecutor, the judge wants to reconsider a ruling and reverse it. And the Supreme Court said judge couldn't do so. At that point, it constituted an acquittal because the state hadn't imposed any rules. Just say you're from out of the country, get free stuff in mass. Well, not to put too fine a point on it, but if I made a material misrepresentation in order to get a benefit from Massachusetts, there's a word for that. It begins with an F. At that point, it constitutes an acquittal because the state hasn't imposed any rules, whether by rules of criminal procedure, statute, or case authority that would allow the judge to do that. But when it recognizes state law has the ability to prescribe something as truly final, as opposed to tentative, and that's the issue here, Your Honor, is that Massachusetts state law does not have such a requirement for the verdict to be returned. Am I a veteran? No. As a requirement, the verdict be returned, announced, and confirmed in open court and provides essential safeguards. For these reasons, the Supreme Judicial Court explained its opinion. It ensures unanimity, ensures no juror's vote or position has been coerced or misrepresented. Commit you for $5 says, dumb question. Does it technically violate the duty of candor with the court to tell a little white lie like we would have asked for mistrial?
New donation from someone.
Thank you, someone. Does it violate the duty of candor? Probably, but of course you'll never be able to prove it. So, secrets between me and the wall, I guess. The Double Jeopardy Clause does not go so far as to say the state cannot impose that requirement. And here, given the requirements, there are no acquittals. It's undisputed no verdict was returned by the jury. Even separate and apart from that, if you accept petitioner's premise, there's such a thing as an acquittal in substance, not form, which the argument advanced in Blueford, it still lacks finality here, Your Honor, to be an acquittal for the reasons set forth in Blueford. Amelia Walsh for €5 says, Bev is allowed, the dog bite expert has been allowed to testify, bringing crash daddies. Yeah, I heard that earlier, that allowing the dog bite expert. I don't necessarily have a problem with that in first principles, but presumably the judge would have to reverse their decision that you have to be an MD, which never made sense to me in the first place. And as to whether or not the ARCA experts can testify, the problem isn't that they're MDs or not. The problem apparently is candor issues. Standing Stone 1776 for $10 says, thanks, Kurtz. I enjoy your show. You're welcome. Yeah, I don't look like a person of color. I'm not. I did a DNA test, 100% Northern European. 100% Northern European. I am all the white. I'm not even partially Italian. I don't even have that going for me. I am all the white. I am nothing but white. I am super white. I am the most white. Even separate and apart from that, if you accept the petitioner's premise, there's such a thing as acquittal, it still lacks finality. And I think counsel mentioned two grounds they contend is indistinguishable. First, by virtue of Arkansas law, I think, in fact, it was the dissent that tried to argue because Arkansas was a hard transition state where you could not proceed to consider any lesser included offense, which also, incidentally, New York is also that, incidentally, by the way. Until there's a finding of not guilty to the greater offense, the four persons report should have been treated as an acquittal. The majority rejected and said, no, it doesn't matter. That's a hard transition state. Jurors are still free to go back and reconsider a prior vote because that's what they do. You could have guessed that. Yeah, you think there's some subtle clues? I might be of the more white persuasion. Who would have thought? Who would have thought? Yeah. And the same issue here, Your Honor, as to why there's no lack of finality. These juror statements don't indicate anywhere at what point during the deliberations the jury supposedly reached out this unanimous agreement. They can't rule out the possibility it may have been the very initial straw vote or poll, and jury continued to deliberate subsequent to that, and the jury might have changed their mind. I know petitioner says it's purely hypothetical the juror did change their mind. That's exactly what the court in Blueford said. It's unjustified to assume no juror might change their mind. In other words, the hypothetical is significant and should be taken into account. I haven't heard of that drug, Sarah ER. Send me an email reminding me, or otherwise I'll forget, but I might check into it. Vasco for 999 said, thank you for your knowledge and snark. Makes my soul-sucking corporate job easier when I can listen. You are welcome. Thank you for being here. They could have voted not guilty or guilty in the jury room, filled out the verdict slip, walked into court. At that point, a jury was still free to change their mind and say, you know what? I think petitioner's actually guilty. I think it's important we deliberate. Fair enough. There is a reason we poll the jury. There is a reason they poll the jury. They can't rule out the possibility, Your Honor. That's what deprives these statements of finality that would be required even if accept the premise there can be an acquittal in substance, not in form. Then just lastly, Your Honor, on the issue of post-trial inquiry, I'm not aware of authority in either direction to suggest the court has the ability to conduct this type of voir dire and whether it might be ancillary to the court's power. The court. I don't think, as Mr. Weinberg has pointed out, I don't think there's any question that I would have the ancillary power in a 2255 in a federal case. Ineffective assistance of counsel, sometimes we do conduct those inquiries, right? Sultry Catley for 999 says, I have depression too, yay. Hanging out with you makes me happy too. Can I just say that Judge Canoni is a major masshole? P.S. I'm on Wegovy and it works great. Yeah, I've had a lot more success on Mounjaro. So I tried semaglutide, and I personally had side effects, namely nausea. The nausea was really, really bad with semaglutide. So semaglutide did not work for me, but Mounjaro, I've had no side effects. So it's been great. It's been great. I just don't want to eat anymore, which is kind of the goal. And as of this morning, let me check my app because I weigh myself every day now so I can feel validated about myself. Let's see what I was at today. What am I trying to do right now? I'm trying to open my scale app. What is the name of that? Okay. Yes, of course, there's a scale app. There has to be, right? As of today, I was at 356.2. Outstanding. I am down 13.9 pounds since February 6th, according to my app, which is when I bought, well, no, I didn't buy that. Actually, it's a little bit better than that. I am down 13.9 pounds since, what date is this? Since the 23rd of February. Is that right? Yes, it is. I am down. Hold on. Yeah, I'm down 13 pounds since the 23rd of February. 13.9 pounds since the 23rd of February. That's pretty good. I'm down 35 pounds off my peak over the last 2 months or so, including when I was on the semaglutide. So, outstanding. My BMI has gone from 50.2 on February 19th to 48.4 today. We're making progress. We're making progress. Let's see. What's at least factually troublesome to me is the notion I'm either stepping into the shoes of the state court or telling them to do something, and maybe I have authority, maybe I don't. But I feel more comfortable with some precedent one way or another, and you agree, I think, with Mr. Weinberg. There's no precedent, at least none you found on the subject. Yeah, the federal judge is like, I'd really prefer there be some guidance on this too. I appreciate that, 100%. Not that we found, Your Honor, exactly, and we do argue in the issue of comedy. If there were to be such a post-trial inquiry in the first instance, it would be appropriate to have the state court do that, but we contend, obviously, that conducting such an inquiry would be inappropriate as not required here. I mean, in one sense, counsel speaks to having satisfied their burden of production. I mean, that acknowledgement that more is needed to actually establish there's an acquittal under a court as it currently stands doesn't do so, I think is an acknowledgement there's in fact no acquittal, and there shouldn't be an inquiry, but the real crux of the issue is where the inquiry goes to. That's the thing. What does the inquiry go to? Why are we asking the question? You doing Zepbound? Zepbound is also the same drug as Wegovy, or same drug as Mounjaro, so it's the same drug, just with a different label. So Zepbound and Mounjaro are the same thing, so that's cool. It's the same exact drug, it's just with a different name. Certainly, the Fifth Amendment right with respect to double jeopardy is a bedrock principle. As significant as the Sixth Amendment right to counsel and other constitutional rights, that's not the issue. Thank you, Colin Miles, for the 5 gift memberships. The distinction is the inquiry they want to conduct here goes to deliberations themselves. It's internal. It goes to right to what the jurors said, what they did, how they voted, why they voted the way they did. It's not simply limited on an external issue that's been held to be appropriate in other circumstances. External issues like racial bias, that sort of thing. Exactly, Your Honor. Extraneous influence or racial bias. It goes to the very hard deliberations. They can't get around it no matter how they try to portray the question. You can't ask a yes or no question to get to where they want to go. For one thing, that's not how we ask jurors to make decisions. We don't ask them to hold up placards that say yes or no. That's cute. Or submit an affidavit that suggests how they vote on the issue. We ask jurors to reach a verdict through collaborative discussion and consideration of the evidence. For another thing, as we pointed out in our brief, this type of yes-no inquiry doesn't give any juror the ability to explain the nuance that might have been part of their position. They may have tentatively agreed in favor of not guilty on a particular charge, but was subject to further deliberation on other charges. How the jury came out of those charges may be further discussion of further pieces of evidence. You simply call the jurors back in and say, I don't want to hear anything about your deliberation. I don't want to hear anything about your thought process. It's just tell me yes or no, did you vote that way? It doesn't give the jury an opportunity to explain their position was far more nuanced than a simple yes or no, and that's the issue. Cool. Also, since petitioner wants to simply focus on the end result, but you can't ignore jury results, notes, and what they publicly reported. You couldn't have had any confidence this was the alleged unanimous agreement was, in fact, reached without reconciling. Well, why is it you sent a note that you were in an impasse of the charges? In addition, why is those one of these 5 purported jurors said it was not guilty on count 1, but doesn't say not guilty on count 3, when the other 4 says it was at both charges? And in addition, why do the 3 different purported jurors have different recollections as the vote count of count 2? All of which goes to, Your Honor, jurors may have different memories, different understandings of what occurred during deliberation, and that's why it's critical, rather than guessing, rather than calling jurors in and interrogating them to try to construct a verdict that was never returned. We insist upon returned and affirmance of verdict in open court because that ensures unanimity of a jury and finality of deliberations, and it's an important rule that protects criminal defendants. What's the benefit of this filing this when it's clearly a long shot? Hope that they might say yes. It's not frivolous. It's not zero. The odds are probably, well, it depends. We haven't gone that far because we're getting toward the end and they still haven't discussed the issue of consent, which to me is weird. So I don't think they're going to discuss the issue of consent, which is really weird to me. Because to me, that's like the more important issue or the more interesting issue. But no one even mentions it so far, which I find odd. But okay, I mean, Change the hypothetical here and imagine a mistrial is declared after the fact. A juror comes forward and says, hold on a second, we all took a vote and we all agreed the defendant was guilty of murder. It's like, imagine the reverse. I've said that many times. Like, imagine this in reverse. If the Commonwealth were to come forward and say they found her guilty, that should be given legal effect. There can't be any serious doubt. She would argue strenuously that's not a valid verdict, shouldn't be given legal effect, and she would be correct because it's not. The same rule should apply. That much I agree on, man. Like, what if this was the other way around, right? If the defense would be screaming bloody murder and all the rest of it. And yeah, and it has to be the same rule both ways. It has to be the same rule both ways. That much I agree. Mr. Schellinger, and Your Honor, unless you have any questions or anything else I could address to be helpful, we'll rest on the remaining arguments in our brief.
New donation from Amy Brooks.
Thank you, Amy Brooks. It's very kind of you. Thank you for the super chat, or the donation on Ko-fi, rather. And then the court says, all right, Mr. Weinberg, quick response. Thank you, Your Honor. First, I want to address the state's position. The state's finding somehow diminished decision-making role before Your Honor. It may be Supreme's judicial interpretation of 27B is correct, but it doesn't. Whether it's correct or not correct, it's binding on me as a matter of state law, yes. And I'm not asking Your Honor to reverse a state law decision by the Supreme Judicial Court, but it doesn't preclude Your Honor from determining the values that are represented by 27B constitutes a viable alternative the judge didn't carefully consider. I'm not sure whether or not that's true or not. When the state talks about defense counsel would want a mistrial, I think that's speculative. I agree with that. And yes, there's some speculation in the Justice George's decision, but that doesn't bind the court from looking at this record and determining that the record, how defense responded notes 1 and 2, was the antithesis of the speculation. Defense wanted a verdict from this jury and never asked for a mistrial and urged the Tui Rodriguez instruction, which oftentimes defense lawyers don't seek because they don't want a verdict. When the state court talks about how it would have been improperly coercive, there's simply no basis. It misunderstands how a judge can frame questions without being coercive. That's, again, a federal decision whether or not this jury could, on a post-trial voir dire, be asked some questions that would not trigger or not catalyze some disclosure of their mental process is something Your Honor has experience to determine. That part is fair. There may be questions to this jury that would answer many states' concern about, did the jury reconsider, was this a tentative vote? Your Honor can ask the jury Your Honor can ask a jury whether you ever discuss count 2 again, whether you ever reconsidered your decision on count 2, whether you ever considered a final vote. These are all questions either at or outside the boundaries of 606B, which literally applies to asking juries to impeach a verdict, but does not literally apply to the unique circumstances where judges have disclosed an acquittal that remains undisclosed because the jurors did not announce it. Interesting way to interpret the rule. I like that. That's very creative lawyering. I like that. And then, of course, we have a constitutional issue that I've referred to from Villar that Judge Saras wrote about while sitting on the First Circuit, which is whether or not the Constitution trumps Rule 606B, whether or not the values and interests at the heart there, the right to a jury trial before an unbiased jury, and here we argue the right to benefit of a jury trial, which then flows in double jeopardy, historic and valued protection against the right not to be put to trial a second time, would require some fact-finding, would require an opportunity to prove it. The state argues, well, 4 people aren't enough, but the burden on the state, and they should be supporting the voir dire because Your Honor could find an acquittal based on 4 jurors could find the state has not met their heavy burden to prove that re-prosecution is viable when the state opposing a procedure that could illuminate for the court whether or not those 4 jurors, who are not contradicted, or 5 jurors who are not contradicted, were representing a final unanimous decision, only if it legally matters, which is by no means a given. 15 more subs to 144. Let's go. I like that very much. 15 more subs to 144,000. You guys can help me break the 144,000 barrier today. That would make me happy. Let me pull up YouTube's back end so I can get the most precise count. Yeah, 12 more as of right now. Oh, 10 more. It's getting closer. The state argues, well, 4 people. Okay, we read that part. The language from Smith is dicta. I don't know that it is. I mean, that's an interesting way to read it, but okay. Dicta, by the way, is a thing when you say like it's part of a court decision, but it doesn't really count because it wasn't required for the decision. So I was like, I'm not sure if that's true, but I do appreciate your enthusiasm. 143,999. We need one more. 144000. There we go. Thank you. Thank you for hitting that subscribe button. It is appreciated. The sign, by the way, may or may not update right away. I'm not sure what its lag time is. So if it remains at 143 for a while, don't worry about it. It's not necessarily as live as whatever. That's why I pulled it to the back end, because it's more reliable. The language from Smith is dicta. It's not holding. And the final point I want to make, unless the court has questions, is the Renico case clearly relied on by the state, where the Supreme Court's made very clear its introduction, then its holding, that it well could have reached a different decision to invalidate the state's mistrial order if it was 2241, where 2254 only allows for reversal of clearly a misapplication of known Supreme Court precedent, not First Circuit precedent, or in this case, I believe it was Sixth Circuit precedent, is a very different case. But within the case, they talk about the decision to declare a mistrial is left to the, quote, sound discretion of a judge, but the power, this is from majority opinion. Is this Renico, says the court? Mr. Weinberg, yes. Ought to be used with the very greatest of caution under circumstances and for very plain and obvious causes. Renico likely would have been reversed under Judge Cannoni's decision under the Perez case, under Supreme Court's multi-factor test had it been 2241. Over and over, they talked about ADEPA prevents defendants from using federal habeas as a vehicle to second-guess reasonable decisions of state courts, whether or not the Michigan Supreme Court opined restating Lett's conviction in the case was correct. It was clearly not unreasonable. And the language in Renico is consistent with your Honor's decision that we urge and we, of course, contend should reverse the state's court's discretion because of the absence of manifest necessity. Lastly, McAlrath, which the most recent 2024, there again, was Georgia law, a Georgia ruling, a Georgia procedure invalidating a jury findings based on idiosyncrasies of state law that the said acquittal needed to be consistent with other counts. And I think it's a clear example of the fact that state law does not govern when state law conflicts with federal constitution. Of course it doesn't. That would be really dumb. How could state law possibly determine whether state law conflicts with federal law? That would be nullification doctrine. We rejected that a long time ago. In this case, we strongly contend it does for two reasons. First, there was a unanimous verdict to acquit to find state's case insufficient to vote not guilty. Second, there was no manifest necessity under any factors that either the Supreme Court or First Circuit looked to justify the precipitous sua sponte ruling by Judge Cannoni. The court, Mr. Schillingler, last word. Mr. Schillingler, nothing further, Your Honor, unless you have questions, thank you. The court, thank you. It's well briefed and well argued on both sides. I'm quite conscious of what I understand is the April 1st retrial date, and I want to try to issue an opinion to give whichever side is, or both sides, if they're both unhappy, which, which is always a non-zero possibility. Both sides might be unhappy. Yeah, that's definitely a possibility. With my decision, an opportunity to do an expedited appeal, so I'm going to put this opinion out as quickly as I can under the circumstances. There's quite a lot to consider here. Mr. Weinberg says it's a wilderness. It's a thick forest anyway, if not an actual jungle. Our metaphors are rich over here. But I'm going to pick my way through it as best as I can, render a decision as quickly as I can under those circumstances, which, as you know, if I had a year to write the opinion, might be more scholarly. But I'm going to make the best decision I can. So again, there's an opportunity to appeal before the retrial commences. Thank you. We stand in recess. That brings us to the end of the transcript. Now we will have commentary time. One moment, please. Okay. First thing that strikes me is there was not one word of discussion on the issue of consent. Not one word by anybody on the issue of consent, which I find perplexing. Because it's like, okay, am I getting something fundamentally wrong here? Right? It's like, am I getting something fundamentally wrong? It's like no one mentions it. Not the judge mentions it. Neither party mentions it. It's like, am I making some sort of fundamental mistake here? It's like, what am I missing? Or what am I misunderstanding? It's like, I'm a little confused by this, to be honest. So that's interesting to me, that there was no discussion as to the issue of consent. So that strikes me as a bit bizarre. So I don't know what to think about that, but it makes me rethink my thinking. So I'll ponder that for a while and try to figure out if I made a mistake somewhere. As to the issue of manifest necessity, taken alone, if this turns on manifest necessity as opposed to consent, then Karen Reed's odds, I think, go up dramatically. So if consent is not part of this equation and it's just manifest necessity, I mean, I think Karen Reed's odds go up from like 10 or 20% to like half or maybe even a little bit better. Because I think, I mean, the only thing that sort of prevents that from happening really is the idea that the Supreme Judicial Court's determination that the judge did exhaust their findings or did consider the alternatives. The only thing that prevents that from happening is that being a question of fact, which the court is stuck with. And so if they're not, then they're not stuck with anything. All the factors seem to go against the Commonwealth. And so her odds go up like dramatically, I think, based on the First Circuit precedent. So that's interesting. The fact they didn't discuss it at all seems to think that no one thinks it's a factor. The consent issue, no one seems to think it's a factor. So, like, maybe did her odds go up to like even money, or maybe even a little bit better than that? Maybe. Yeah. So interesting. Very, very interesting. Very, very interesting. Oh, consent to the mistrial. Sorry. Consent to the mistrial. That Karen Reed consented to the mistrial. In this case, by failure to object. She consented by her silence. She did not raise the objection, and because she didn't raise it, she lost it. That's consent. Sorry. You can also call it waiver if you prefer. I think the term waiver is less charged than the term consent, but the case law calls it consent. I would call it waiver because I think it's less charged language, but it basically boils down to the same thing. You failed to object. You had an opportunity to object. You failed to object. You lost the objection. It's gone. That's what that issue is. So sorry, I didn't specify that. Christina McVeigh for 499 said facts. Commonwealth has no lawful integrity. In this case, Lady Justice's eyes are wide open, not blind. We need to embrace radical acceptance of Commonwealth's crimes. KGMV for 1999 says, I'm so happy you asked Melanie Little to send me here. Love your energy. I know I'll learn a lot from your channel. I hope so. We try to do a lot of legal analysis stuff. Does the state have to adopt the federal courts? Well, if the federal court puts an injunction, then they have to obey the injunction. So yeah. So yeah. Oh, I do try to remember you guys don't speak law speak to me as well. I do try to remember that. Yeah, I wasn't trying to talk down to you. I was apologizing because I didn't define my terms. I kept talking about consent and I didn't specify it. I wasn't insulted by your question. It was a perfectly reasonable question. It's just I just kind of forgotten to specify exactly what I was talking about. It was my fault, and I appreciate the question so I could clarify it. Is there hope? Yeah, there is some hope. There's some hope, perhaps even more than I anticipated. 144022, by the way. The numbers keep increasing. You keep increasing at this rate, maybe we'll hit 145,000. That'd be nice. Let's see if there's any other fan funding chat that I've not raised. I think I've hit everything. Colin Miles gifted 5 memberships, became an uncivilian. Bijou Cooper became an uncivilian. And I think I've acknowledged all the super chats at this point. So I appreciate all that stuff. Anything more? Prosecutor dog bite guys rolled in. Yeah, we saw that. We could hypothetically download that decision and cover it right now if you guys want, or at least skim it. I don't know if I necessarily have the most energy to go through it in full, but there are 2,000 of you here, and I hate to give up an audience. So if you guys want, can someone send me a copy of the judge's decisions from today, and we can at least skim them. I won't necessarily promise I'll read every word, but I'll skim it and give you the highlights. It's on Discord. It's only a few sentences. Excellent. See, this is why my mods are good. My mods beat me to the punch. My mods are good. Sometimes they're competent. Sometimes my mods are competent. And they do a good job. Well, this is completely unsatisfactory as a decision. This is very unsatisfactory as a decision. This is one paragraph. This is not helpful, Judge. This is not helpful. Hold on, let me pull it up. Yeah. I could have used some more verbiage. All right, here is all of one paragraph. Very, very well reasoned. Very, very well reasoned. Decision in order on defense motion to exclude the testimony of the Commonwealth witness James Crosby, PhD. After hearing and reviewing the pleadings, the court finds the Commonwealth is satisfied the foundational requirements of Daubert. The evidence will assist the jury. Daubert is an expert, or Dr. Crosby is an expert in dog bite wounds, but not an MD. There's an appropriate basis for an opinion in the record, and his proposed testimony principles and methods are reliable. Defendant's objections goes to the weight of evidence, not admissibility. Defendant's motion to exclude is denied. So what is the rules relating to whether you have to be an MD or not now? The judge doesn't say. The judge doesn't say. Like, oh, I made a mistake and I'm overruling my prior ruling or anything. The judge doesn't say anything. I am displeased. Like, if you made a mistake, judge, just say you made a mistake. That's fine. Judges make mistakes. I made a mistake. I shouldn't have said that. You don't have to be an MD. Sorry for the confusion. But you don't even say that. You don't even say that you made a mistake. That's lame. It sort of suggests that some people have to be MDs and other people don't have to be MDs depending on your whims. And that's no way to run a courtroom. That's not good. Thank you, Nikki Thompson, for becoming an uncivilian. So can ARCA testify on the wounds? One would think. Maybe not. Maybe because they're not dog bite experts. So they don't have any idea about dog bite experts. They're not experts in that. Yeah. Does that mean that crash daddies can now opine that the cause of John O'Keefe's death was not the car crash? I don't know whether it means that or not, because there's no logic. It's just a conclusion. So you guys are asking me questions which are not unreasonable questions, but I have no answers because there's no logic. Right? So I can't say, oh, because of this, therefore this. It's just like, here's a thing. It's like, okay. So I'm saying, what's the rule? And then you guys are like, does that mean the ARCA people can testify? I have no idea. How would I possibly have an idea? I don't know what the rule is. She won't tell me. So I have no idea. What do you want from me? I don't know. Hold on. I do have an answer for this. I do have a tool to answer this question. I have a tool. Hold on one second. I have an answer. Okay. All right. What was your question? What was your question? Will the ARCA experts be allowed to testify about whether it's a dog bite crash? Most likely. You have any further questions? Can they use Melanie Little Dog Expert now? Outlook not looking good. Can we bounce this judge? Reply hazy, try again. Lol. The Magic 8 Ball knows everything. Is the judge biased? As I see it, yes. The Magic 8 Ball does know everything. The Magic 8 Ball is our new god. All hail the Magic 8 Ball. The Magic 8 Ball knows everything. Excellent. Excellent. That is the best part of my day right there. I'll tell you what. Yeah. I wish the 8 Ball was making all the decisions in this case. Yeah. Hello. I am Magic 8 Ball, and I'm running for the Judicial Court of Judge Canone's district. You know, Judge Canone's been on the bench for a long time, but you know, I'm a Magic 8 Ball, and I have some interesting ideas on justice. Elect me to be your new judge, and I promise you swift judgment, and quick resolutions. All your questions will be answered from the bench. You won't have to wait for a separate motion. And you will know the answer immediately with wisdom and grace. I'm Magic 8 Ball. Please vote for me. Paid for by supporters of Magic 8 Ball. Oh man, what else can we talk about? Oh, I'll just comment very scatteredly about the Turtle Boy thing. Okay, so just like by way of like, I've not really been looking into the Turtle Boy lore, and so I don't really know for sure what's going on in the case. I was like very loosely paying attention in Melanie's hearing, kind of coming in and out as I was doing other things. So I just kind of heard a scattered word here or there. So I don't really know about the Turtle Boy thing. But what little I did hear from the hearing today didn't exactly convince me that the state necessarily has the greatest case. Maybe I'm not getting a full picture because I was just kind of scattered in and out. But it seemed like some of that might be protected First Amendment activity and not necessarily like jury intimidation. So, and also at one point they started talking about torts. I tuned in for that. At one point, the prosecutor was saying that someone could sue Turtle Boy for defamation. Did we turn into a civil court when I wasn't paying attention, or what? I don't know. Did we turn into a civil court all of a sudden? I don't know. So I don't know. It seemed a little odd to me. But you know, okay. But maybe the state's case is better than it appears. It could be. I owe you a beer after spinning out with the 8 Ball move. Michelle Mongan says, I didn't change my mind. Free Karen Reed. Yeah, fair enough. If that is a juror, you're always welcome to contact me on my channel. In fact, if you want to, I will figure out a way to do a live stream on the fly. You could even join me by phone. That would actually be easier for me. So if you want to join me to talk about your experience on the jury, let me know and we can talk about it. It'll be fun. That'd be a good exclusive. Random, that'd be good. Interviews with a juror. Yes, if you're a juror in this case and would like to talk about your experience and your thoughts about the Commonwealth, and if you're a juror and you know the answer to how long to die in cold, I'd really appreciate it, because no one has yet told me the answer to how long to die in cold. It is a question that continues to haunt me. So if that came up in jury deliberations and you can tell me the answer, I'd really appreciate it, because I've been wanting to know for a long time. Do I want to get married? Well, I want to be married. Yes. Check Discord. I'm checking. What am I checking? Oh, Melanie's going live. Outstanding. No problem. I'll kick you back that way. That's fine. We were in the stream anyway. All right, I'm going to kick you back to Melanie. Hold on. I'm going to kick you back to Melanie. Give me 1 moment, please. Oh yeah, she's live. No problem. I'm kicking you back. I'm kicking you back. We do appreciate it, and we're going to return the favor. All right, hold on. All right, let's see. Where's the redirect button? There's the redirect button. Okay, where's she? Where is you? Where are you? There you are, Melanie, in my redirect. Hit save. Settings saved. Okay, guys, it's been fun. It's been real. I'll see you guys over on the Melanie stream, where I'm sure we'll have even more fun discussing Karen Read stuff. I've been on Civil Law. Until later, my friends, I hope all is well. Cheers for now, my friends, and goodbye.